filed an application before your lordships, and my lord, an order was passed by your lordships on 31st of January 2023, by which, my lord, it was regularized. But by then, those two checks and the demand draft, my lord, had expired. So, my lord, we, instead of, my lord, pursuing that, we made fresh payments pursuant to your lordship's order, my lord, of 31st January. We made the payment. It is now regularized. So these three, and it is continuing. We are making payments, my lord. But the two checks and the demand draft, my lord, they are with the registry. Now, those are, my lord, checks are of no use because, my lord, the dates are gone. And the demand draft now, because of audit purpose, my lord, there's a letter which has been written on 21st of April 2023.
Make a one-page application with notice to other side. We shall do the needful.
We'll do that, my lords. We'll do that. I'm very deeply obliged, my lords.
Yes.
I am praying for the petitioner, madam.
Lord, I've got the report, Lord. Okay, the check for. Pursuant to Lordship's direction, Lord, there is an inquiry committee, and the inquiry committee, Lord, examine, Lord, all the staffs, Lord, who are available on that particular date, and ultimately on inquiry, the inquiry committee finds a report indicating, Lord, that it was the latches on the part of the Lord, the security guards, Lord, they were not vigilant and they were not doing their work properly because the nurses and the doctors, blood, are the other, and hospital staffs, blood, they are, blood, busy in treating, blood, the patients. Now, blood, so far these entry and exit of blood visitors as well as blood the persons, patients, blood, that are being taken care of by the security guards. Now, your lordship would kindly see, blood, the exhaustive report of the committee, blood, which has been
the mutation can be, since we challenge the overall the process of division of the partitions. So now mutations made by the
So
authorities.
what is the wrong done? You have not obtained any order from the school.
No,
Arthur, my lord, that has been filed by the dead person even. Appellants are three. Three appellants are there.
that time they were present.
No, that's been filed in 2023, I think. 2023, this has been filed. That has been filed by a dead person.
Okay, you file reply, then we shall consider. আচ্ছা। আচ্ছা, Mr. Such and such file it in opposition to the application for Mr. Song.
The respondents.
The respondents have filed affidavit of opposition to the application for condonation of delay and to the application for reliance. আচ্ছা। Mr. Such and such advocate appearing for the appellant applicant based for liberty to file, based for extension of time. Based for liberty to file. Let such reply be filed. Let such affidavits in reply be filed within 1 week after the vacation. Is the matter for the consideration. 2 weeks after.
File your reply within a week after the vacation.
Well, and also praying liberty to file the substitution application since the appellant number 3 was.
What liberty? Why?
No liberty is required.
Well, kindly fix a date, my lord.
1 week after the vacation.
1 week after the matter will appear. Great.
2 weeks after the vacation.
Grateful.
Which matter I am appearing on behalf of the respondent.
My lord, I am appearing for the appellants. Applicant
Suit
here.
for-
Applicant appellants here.
For?
Suit for my lord,
Actually, shall I hand over the copy of the opposition to the application for condonation of delay?
You have used,
I had
I'll
some
be
copy.
received.
you have reply you have used.
No, my lord, no reply yet been used, my lord. Since it was
1 week
supplied on 11th, my lord.
Oh, yeah.
Long ago, I have supplied. It is a fact from the record. There is nothing can be denied.
He kept on record.
for June
For-
and
for-
respondent. You are for respondent numbers?
But sole respondent.
ঠিক আছে। Learned advocate for liberty to file immediate reply. Let such same order.
There are two opposition. You have filed 2 opposition.
Only one opposition I have filed
Uh.
because it is an application for condonation of delay with a supplementary affidavit as per leave of my lord. Not 2 application is there.
They keep
I
filing-
believe one is for stay.
One is first.
I believe one is for stay, another is for section 5. In connection with the section 5, a supplementary affidavit explaining the delay has been filed,
So
which has
you-
been served on me.
Now you have filed 1 opposition.
Opposition to the section 5 application, along with the supplementary thereto.
The learned advocate appearing for the respondent has files the affidavit in opposite appearing for the respondent. Files the affidavit in opposition to the application being can 1.
Can
One.
one, my lord.
Let the same be kept on record. The learned advocate appearing for the appellants prays for extension of time to file the reply.
The reply, my
Such
lord.
reply be filed within a week after the vacation is the matter for further consideration 2 weeks after the vacation.
Lord, in fact, I would not have even taking the pending of there is a fee fighting between the parties. Even the advocate has been beaten by my learned friends.
Huh?
What I am saying,
can it be shorter? My lord, because there is nothing. I have only relied upon the certified copy of the order of my learned friend's application.
Let them file and reply. They had
So you, section
I have relied on the certified copy of my learned friend's
So
case.
do we allow the application for section 5?
No, would not be because it cannot be. Because if they would have come with a fair hand, well, I could have understand. They have palpably
how
misled
you
the
will
court.
show us the certified copy, if don't allow the continuation of delay?
Well,
We are
I
eager
will
to
satisfy.
we
I will
are
satisfy.
eager to see the certified copy of
They
the
have
degree.
said that I have no knowledge. But repeatedly
Oh,
they filed a separate case. There they lost. Then the appeal has been prepared.
oh.
That is why you are here.
Yes. Well, so they should have come with a fair hand.
Yes. Next.
Grateful. Well, can it be fixed date otherwise to your
1 week. It will appear 2 weeks after the vacation. Yes.
Grade 6 milord, I lecture here.
Item.
6, my lord. And I'm for the appellant, milord. Yesterday, milord, I have thoroughly checked up the record. Milord, I find, milord, some mistakes are there, milord, in the cost item. Milord, may I narrate before your lordship? This is, milord, the affidavit of service in respect to the CAN 5. The addition, milord, this is, milord, preliminary decree, milord, reopening of the preliminary decree on the ground that several transfer took place in between. And milord, for that reason, milord, one of the transfer, your lordship 6, milord, gives me leave, milord, so that I can file the application for additional evidence. At the time of milord serving the copy of this additional evidence, milord, my learned friend appeared now, milord, for one of the milord defendant.
For one of the defendants.
Yes.
No, last day paid for time to.
Now, milord, if your
You
lordship,
want to file opposition to that application.
yes, milord, to that effect, milord, he has to, milord, but may I point it out before your lordship, milord, there are certain mistakes, milord, in the cost title. But if your lordship takes up, milord, CAN 5, milord, what happened? My advocate on record drafted this petition, milord, as per the cost title of the milord paper book, milord, has been prepared. But milord, there are certain mistakes. If your lordship takes up, milord, CAN 5 once,
CAN 5 the thing.
What is this CAN 5?
CAN 5 is milord for additional evidence. Order 41, Rule 27 application.
Then we judge along with the
Yes.
appeal. Then what you are pointing out?
No, milord. First, milord, if your lordship takes up page 2,
Why you have filed original deed along with this?
milord, your lordship knows, milord, for 4127, milord.
No, now you are saying application, file original before the court if your application for additional evidence is allowed.
But sometimes, milord, in the appeal, your lordship's milord, view was that, milord, since
Giving the responsibility
Who will
on court. If it is lost, you will never be able to give original back to your client.
Since, milord, the veracity of the evidence your lordship has to scan, that's why, milord,
here
I can take back, milord, by producing a photocopy of the, milord, sir. If your lordship
file a fresh application annexing Xerox copy, make the statement original is with you. Because it will be responsibility of the court. If
Oh,
this application goes missing,
Uh,
responsibility of the court will be fixed. But what happens to your client?
milord, yes, kindly takes up page 2 once, the cost title.
Mr. You please file a fresh application with a Xerox copy.
That I can do.
Take back this application. This cannot be.
Pressed with liberty to file afresh, liberty is given to take back.
Recorded.
Liberty is given to take back the original certified copy upon deposition of the photocopy thereof. You give a photocopy, annexed it, and take back it.
Yes, yes, I do have, milord.
লিবার্টি দিচ্ছি ফেরত দিয়ে দেবে এরই জেরক্স কপি এর সঙ্গে জমা দিয়ে দেবে যেমন এইটা দিয়েছে নিশ্চয় এরকম একটা কপি ওতে দিয়ে দেবে
Lord, may I
আচ্ছা
produce the photocopy itself here? So that
হ্যাঁ ওটা দিলে ওর সঙ্গে এটা দিতে পারবে হ্যাঁ এটা দেবেন
ওটা রেকর্ড করে দিচ্ছি আমরা এরকম বলো কি application being CAN 5
আচ্ছা in the application being CAN 5 of 2003 আচ্ছা original deed of sale.
Yes, my lord. Original deed of sale. My lord, may I- deed of conveyance, my lord, dated 29th September 2003. My lord, page 8 details is given, my lord.
Acha, deed of conveyance dated 29th September 2003. Huh?
Original deed of sale.
Sale dated 29th
In the
September
application being can বলেছো তো?
acha, has been annexed. Acha.
Has been annexed inadvertently.
Inadvertently. ঠিক আছে?
Stop, Mr. Mukherjee,
Mr.
prays for leave to
Leave to take back the original deed of sale. ঠিক আছে?
deed of- আগে যেটা লিখেছো সেটাই বল।
Deed of sale,
conveyance বলেছে।
deed of conveyance, acha, dated such and such.
Upon furnishing a Xerox photostat copy
Step copy of the same. মানে উচ্চাইল আছে such prayer is considered an allowed as appellant is liberty to take back the ওইটাই আবার লিখে দিন। আচ্ছা হ্যাঁ না 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 ও হারিয়ে যাবে এক্ষুনি নেই এক্ষুনি দিই। আচ্ছা liberty is given to the Mr. Mukherjee to take back the original deed of conveyance in court today and to furnish the photocopy thereof. ঠিক আছে?
জজ সাহেব এখান থেকেই নিতে বলছে।
Annex the photocopy of the said deed of conveyance
হ্যাঁ।
in the application being kept by
ঠিক আছে?
এবার you are appearing for which respondent?
For my lord.
ওপরে এফিডেভিট অফ সার্ভিসটা দিয়ে দেবে। দিয়ে একটা in spite of service no one appears on behalf of the respondent numbers
Operation direction হলো না?
But
1,
your
2,
lordship,
3 and 5. Stop. তারপরে লিখো Mr. Advocate enters appearance on behalf of the respondent number 5 and prays for leave to file an affidavit.
For my lord.
Four.
File an affidavit in opposition to the application being can 5 of such and such. Stop. Let such opposition be filed within a week after the vacation.
My lord, I pray, my lord, 2 weeks after vacation, my lord. My lord, I'll be not there.
In 2 weeks after the vacation.
I'm grateful, my lord.
ওইটা কি বলা আছে? It will be heard along with the appeal. Yeah.
Your
আগের অর্ডারে বলা আছে?
no. Your lordship's view was that after their appearance, your lordship will.
ও তাহলে ওরম লিখে দাও।
নির্দেশ to observe বা mention.
The application within a opposition within 2 weeks after the vacation, reply thereto if any be filed within a week thereafter. Stop. The application being can such and such will be heard along with the application. Please the matter for final hearing in the final hearing. ওই কত বলেছে? 3 weeks after the vacation.
I'm grateful, my lord.
Please the appeal for final hearing along with the application. 4 weeks after. You have taken back the certified copy?
Such, lord, the original deed.
Original, হ্যাঁ।
Original deed, no, my lord. After your lordship's order, your lord, I shall produce, my lord, the photocopy. My junior will be here. Lord, he shall produce.
In court বলে দেওয়া হলো তো।
ইনপুট দিলে অসুবিধা নেই। কোনো ফর্মালিটি
কনভেন্সের উপর কোনো স্ট্যাম্প ট্যাম্প পেল নেই তো তাই
স্ট্যাম্প পড়ে যাবে, ওটাই বোঝা যাচ্ছে।
হারিয়ে যেতে পারে, আবার যাবেন আবার দিয়ে দিন। হ্যাঁ, কোনো ইয়ে নেই।
স্টিচ করতে হবে ফাইলিংটা। অরিজিনালটা দিয়ে দাও, ফটোস্ট্যাট কপিটা অ্যানেক্স করে দাও অ্যাপ্লিকেশনের সাথে, করে রেকর্ডে রেখে দাও। You ask your junior to do
Yes,
the-
yes, my lord, he will be present, my lord.
and hand it over to us. Check up করে নাও অরিজিনাল।
Original টা মিলিয়ে দেখে নিন।
Receive back the original.
না ও ইয়েতে একটা বাঁদিকে একটা লিখে দেবে যে বাই ভার্চু অফ দিস অর্ডার ডেটেড অরিজিনাল ইজ টেকেন ব্যাক অ্যান্ড কপি
Photostat
ফটোকপি
copy is annexed.
বলে সই করে দেবে।
In the photostat copy at the corner, you just write that the original copy.
Original is taken back and photocopy is being produced. ঠিক আছে বলে সই করে দিন।
In the application cost title at one side, put that note, that original taken back in terms of this order,
Fine. ঠিক আছে?
and put your signature.
Signature date.
Grateful. Grateful, madam.
তো 10খানা অ্যাপ্লিকেশন ছিল। 8, 9, 10
Seven Malad, I beg to appear for the applicant.
My lord, Mr. Oyun Banerjee is appointed as a special officer, your lordship. He has filed his final report. If your lordship kindly fixed it tomorrow, my lord, then we can.
It's a partition suit, my lord. Mr. Banerjee was appointed
The
as a
special officer.
special officer, partition commissioner for keeping effect of the partition, my lord. Inspection has been over. Mr. Banerjee will take some
Complete.
time to prepare the revamp for the applicant.
How long time this is the fourth time it is appearing.
My lord, inspection has happened. I am for the appellant, my lord.
If your lordship kindly fixes it tomorrow, my lord,
1 week after vacation. Yes,
1 week after vacation. Tip.
eight. But you are first time application.
Yes, I appear for the plaintiff respondent.
You are
my appeal, my lord.
It's an appeal from a
Well,
decree.
But it appeared, my lord, and that day, my lord, I took time, long, my lord, 3-4 months back, my lord, because this is a change brief, my lord. I have to go through the entire record, and lordship was pleased to give me liberty to mention, but instead of, my learned friend has mentioned this matter for listing, my lord.
What are the applications?
My lord, there is one condonation of delay and one stay,
How many days delay?
48 days, my lord.
Which possibly
not
is not correct, the computation. But as far as my calculation goes, it should be 89.
You are better in mathematics.
My lord,
The stamp reporter.
but I have, I do not know what the stamp reporter's report is because it's a
So your
petition.
junior ought to have checked it up.
But if your lordship kindly takes a look at the,
We are looking at the report, 29 days delay. Now, please show us.
my lord, that calculation is on the basis of 90 days. It's an appeal from city court. It should be 30 days.
When was the judgment? 18 December 2021.
My lord.
18 December.
18
The
December
application-
21. 90 days takes us to March 2020.
It should be 30 days, city civil court.
It is from.
It is from city civil court. Had it been any other lower court, it should have been 90 days, subject to correction, my lord. That is why, my lord, 29 plus the difference.
I
my lord,
have also calculated on the basis of 30 days, my
possibly
lord.
89 days. And I have made a detailed breakup of the calculation.
Oh, 60 days, 60 days.
Yes. That is the difference, 60 days. Instead of 90,
So you are opposing.
I am opposing. No ground has been made otherwise.
They allow for the-
But only one other indulgence, my lord. I have also, my lord, it's an appeal from a decree where I am, it's my suit. I am the plaintiff. My lord,
Suit for
suit for my lord, declaration and injunction on the ground that I run the business of a commercial shop from the store, from the premises, and it's facing the road. I do not use any other amenities, save and except water.
7 except.
Water.
Huh.
Electricity, it's on my own. Everything on my own.
Now they are obstructing.
What they
your
are doing
egress.
is they are saying A, I will not get voting right. B, I should pay double maintenance as I am using it commercially. C, I should be paying more electricity charges.
Now what the court said.
What the court has said I should be getting voting right and has held everything in my favor. Save and except,
Voting.
save and except one point,
Society te vote দেবে।
it's a society. But I do not join issues with that. That's it's nothing that bothers me. What is bothering me and where the decree has not been passed, so I have preferred another appeal from that portion of the decree.
I
Where
am
my-
not aware of any appeal.
But from challenging that portion, where my lord, I have a mezzanine floor. What they are doing is they are calculating the maintenance charges for 2 floors, taking into account the mezzanine. That's within the area. So they are doubling the area, saying that you have a mezzanine, and they're claiming the double.
Now what?
That decree has not been granted in my favor, that portion. Aggrieved by that, I have preferred my own appeal, which I don't think has yet been served on my learned friend. It has been filed yesterday, but we shall also have to take out a Section 5 application for that. That's in the process. It should be filed tomorrow. But may all these will appear together after vacation any day, so that we can both thrash our respective points. But that is FAT 184 of 2023.
There will be more delay in your appeal.
Yes, much more.
Only one small submission, my lord, I want to make, my lord. Although there is no application on the record, my lord. My lord, for last 3 months, they have not paid any electricity charges, and it's a society. It's not generating any profit.
What is the other appeal number?
My lord, FAT 184 of 2023. That has been filed, but condonation application has not yet been filed. That will be filed tomorrow. But if both can appear together, my lord, subject to your lordship.
We condone the delay so that we can condone your delay also.
Yes, yes. Well, I only pointed out calculation error. I was not standing in the way.
তাহলে দুটো একসাথে শুনানি হবে।
May I make a small submission?
During course of hearing, Mr. Gupta
Learned advocate appearing for
information.
respond. Oh, you are respond number 1.
There is
Only one respondent.
There is only one respondent. No.
No, there are 2.
Yes, respondent number 1.
Yes, sir. Only one.
Original plaintiff or defendant respondent.
Appearing for the
Respondent stroke plaintiff. Respondent stroke plaintiff.
চেঞ্জ হয়ে গেছে নামগুলো
Inform us that
চেঞ্জ করতে হবে মনে হয় তো because I cannot find
plaintiff to respondent has also filed an appeal
না কেউ নেই
assailing thus
এখন
সেটা বলে দেয় my lord, only one thing. My lord, only one thing. Both of us should point this out to your lordship. It's our duty. Well, what had happened is your lordship will kindly see the cost title once. My lord, kindly sees appellant number 1 and 2 are not there. These were the ex-presidents and members of the, my lord, they are the president and the secretary of the society. Now there has been a change in the guard. So at present, none of them are there. And that is why, my lord, my appeal is also possibly defective. Her appeal is also possibly.
my lord.
what is the
Because we need to substitute them with the present president and the secretary. This, my lord,
And this will change again next year.
yes.
So this is
May
the
change.
may change.
you take appropriate steps?
Yes.
Just telling that you have informed us that another
Yes, but
appeal-
kindly do not pass any order today, because there's presently there is nothing there. We need to take out a substitution and then
no, you have filed the appeal.
in a wrong cost type.
So maybe we are recording that
Maybe.
you have filed.
Very
Both has to be hard analogous.
yes.
ঠিক আছে?
দুটোই defective. আমারটা তো আমার নতুন করতে পারতাম না, করতে পারতাম। তোমার করে সাবস্টিটিউট করতে পারতাম। পার্টি তো এর সুটা তো করে সাবস্টিটিউশন করে লিখে দাও।
Assailing a part of the portion of the judgment impugned in the present appeal.
Present appeal. So let the appeal being
সাবস্টিটিউশন দেবো কোন
List both the in both the appeals are both the appeals shall be hard and
analogously let appeal number eto clear along with
জেনে নাও ঠিক আছে।
this appeal being present appeal being effective as a sort of 2 weeks after the petition for
Minutes
ঠিক
of
আছে?
counselor.
মক্কেল জানো।
হলো ক্লিয়ার হলো হ্যাঁ
We have said it will be analogously hard, and we have kept it with 2 weeks after the vacation, and both will appear at the same time. You file your necessary applications in the meantime.
I'm so grateful.
Line, my lord, I'm for the appellant, my lord. My lord, you not remember that matter. That's his mother-in-law. My lord, so file a suit my lord, against the daughter-in-law.
Hmm.
That is a suit for recovery of money, and your lordship.
Mother-in-law, daughter-in-law.
Yes, my
You are for whom?
daughter-in-law.
Oh.
My lord, before your lordship
Take
looks
a-
any further, my lord, I am told that Mr. Parthapratim Roy is appearing for the respondents, my lord.
Every time it appears,
My lord, your
what
lordship,
happened? Evidence
last
which are complete.
no, my lord, not it, my lord. My
No,
lord,
ma'am.
twice, my lord, your lordship give direction.
You are
for
the
file-
appellant.
Yes, I'm for the appellant. Your lordship give direction.
What
to
is the application about?
application for injunction, my lord, execution case, my lord.
What
Starting
was the suit for?
for recovery of money.
Recovery of money.
Your
How
lordship,
much? How much?
but 3 lakhs something, my lord. That is
So that
lying, lying
suit
in
was
the
filed by whom? Respondent number 1. Acha.
mother-in-law.
Mother-in-law has obtained a decree of recovery of money of 3 lakhs.
Yes.
Aggrieved by that, you have come before us.
Yes.
So secure the amount, we will stay your
Your lordship, on last occasion, your lordship give direction to give notice to the bank because all money is lying with the bank. And Mala, I've sent a notice and affidavit service is there. Affidavit service is there. All
bank is not a party to the
Yes,
appeal.
yes,
Yes, yes. Dena Bank, Khagra Bank. Our bank.
yes, and they receive the service. Manager, Dena Bank, the branch manager.
জীবন বীমা নিগম। LIC টাকা বল।
Yes, LIC, the 2 policies is his son during the lifetime
amount
policies
LIC.
and nominee was appointed, my client. Now all money was lying, my lord, in the bank. So your lordship directed to sub notice to the bank. Well, I have sub, they received, but well, your lordship, I have filed affidavit service on last occasion.
What is the 3 lakhs amount?
3 lakhs something.
3,26,000.
Exact amount, my lord. 3,26,079. Your lordship give direction for settle the matter, my lord, on last twice your lordship give to Mr. Roy. But well, not yet, my lord, compromise or settle the matter.
You did not sit together.
No, my client, my lord, when my lord, Mr. Roy, my lord, that he's,
Uttar of Khagra.
yes,
Eh?
Murshidabad, yes.
Khagra. Same place. Yet you are not getting time to sit together.
No, my client is always agree. But my lord, Mr. Roy, my lord,
Call Mr. Roy. Where is Mr. Roy?
My lord, he is on his legs, I'm
Ask
told.
him to come. When he gets off from his legs, ask him to come.
My lord is keeping it
Pass
at
over.
very.
Ask him to come immediately.
Yes.
You people do not settle. Court has stated one thing. You give no value to the court's observations.
My lord,
Ask him to be here just now.
Yes.
Acting like cats and dogs. Pass over. 12টার সময় রাখো. Ask him to come
Yes,
at
yes.
12,
My lord.
otherwise we deal
My
appropriately.
lord, I shall inform.
Lost and found case হয়ে গেছে। ওকে আরোই লাইটলি দেবে।
Your lordship, I'm appearing for the appellant petition in this matter. Yes, your lordship, I'm seeking extension of time to file affidavit in reply, your lordship. Since the appellant petitioner has not been able to affirm the affidavit in reply, your lordship, he is sick and is unable to come to the court.
The application
For injunction, your lordship.
partition suit.
No, your lordship, it is a matter arising out of letters of grant of probate from other suit, your lordship. My suit has been dismissed and against which I have preferred.
Injunction you want.
Your lordship, they're changing the nature and character of the suit premises by digging up the earth.
Who filed the suit? Who filed the?
I am the
probate
plaintiff in the other suit, which I have filed.
plaintiff in the probate case.
Yes,
Your
your
probate case was dismissed.
Yes, your lordship.
Against that, you are before us.
Yes, your lordship.
Now, are you any possession of any part of the property?
My lord, I am.
Are you both residing at the same place?
Yes.
What residential house?
This is
It's a vacant land, your lordship.
a Bastu land.
It's a,
So, Bastu land. So, it's a vacant land.
yes, your lordship.
It is being cultivated.
No, your lordship in the supplement.
Bastu land.
না, যেখানে বাড়ি
শালি হচ্ছে কি?
এই কাজে।
So, so we will restrain both of you from alienating the property. We will dispose of this stay application.
My lord,
What reasons?
first of all, this appeal is not maintainable on the face of the record. Because this appeal ought to have filed before the district judge. Because
District judge,
yes, my lord,
why?
additional discharge passed this degree.
Additional,
District judge.
pass the order.
That's why as per
Appeal will lie to the district judge
district judge.
from the order of passed by the additional district.
District judge. As per provision of section 388 of the Indian Succession Act.
Huh?
As per provision of 388 of the Indian Succession Act.
District judge includes
No, my lord.
additional district judge.
No, my lord, please have a look at the section,
Bengal Agra Act.
no, 388.
Yes. Government notification you are speaking.
No, I'm reading out the act.
Yes, 388. What you are showing?
Just section 2 proviso.
Huh? 3?
Subsequent 2, any inferior court so invested shall within the local limits of jurisdiction have concurrent jurisdiction with the district judge in exercise of all powers conferred by this part upon the district judge, and the provision of this part relating to a district judge shall apply to such inferior court as if it were a district judge, provided that an appeal from such order of an inferior court as is mentioned in subsection 1 of 384 shall lie to district judge, not to high court.
The application for letters of administration.
Yeah,
Yes.
384-1, what's 384-1?
384 subject to the
Huh.
one subject to the other provision of this part, and appeal
And
shall lie to the high court
Order
from the
of
district
an-
judge.
of an inferior court.
Yeah.
As mentioned in subsection of 384. Now come to subsection 384.
Subsection 3, I'm reading the subsection, entire 384 subject to the provision of this part, and appeal shall lie to the high court from an order of district judge granting, refusing, or revoking a certificate of this part. The high court may, if it thinks fit by its order on appeal, declare the person to whom certificate should be granted and direct the discharge on application being made therefore. To grant it accordingly in suppression of the certificate, if any, already granted. So
So whether additional district judge inferior to district judge?
proviso says so.
Proviso said so.
Provided. Read the proviso. Provided that an appeal from any such order of an inferior court.
Yes,
So
the,
they are enjoying concurrent jurisdiction.
No, my lord.
District judge as well as the additional.
my lord, the case was filed before the district judge. He then transferred to the additional district judge.
Yes, you
Yeah.
contested.
Yes,
To ever raise the question of jurisdiction. You did not raise in the question of jurisdiction.
because delegated, the case was transferred to the additional district judge. How can I raise this? They have the jurisdiction to decide the case.
Yes, so
Yes.
concurrent jurisdiction you are
The-
agreeing. Then where
now-
is the bar?
Bar is that if inferior court additional discharge is decreed any,
Read it in total. Read subsection 2 along with the proviso. Any inferior court so invested.
so invested, that is additional discharge.
So it does not, how it can be an inferior court if it is parallel jurisdiction is being enjoyed?
Not this panel. Additional discharge administratively superior court. The district judge is administratively superior court.
সেটা contested হয়ে গেলে additional decision তাহলে তার অ্যাপিলটা তো হাইকোর্টেই হবে।
Everywhere district judge includes the additional district judge.
Yes.
Section 24 only, CPC says that only in respect of 24 CPC,
Then
additional district judge will be deemed to be inferior to district judge. Except this, nowhere you will get that district judge is, additional district judge is inferior to
the next day I will.
here 388 has given a power to the state government to confer the power of the district judge to any inferior court. Read again.
I'm reading that. Whereas an appeal from such an order of purpose, as mentioned in subsection 1 of shall lie to district judge, not to high court, and district judge may, if it thinks fit, his order or on appeal such and such everything. So this appeal on the post of record is not mentioned, but I have a judgment. Next date I will provide it.
In installment, you will argue. You will argue in installment. Today, let us tell this. If we have got at that point, I will cite a judgment. Give me some time. When you are ready with a jurisdictional point, whatever authority you have, you place before us. Why should we call for affidavits? Not required.
The first of
My brother points out to you, now you say there is a judgment. I will bring it. Give me time. This practice is not proper.
Yes, ma'am.
You should have told at the first occasion that it is a jurisdictional issue. I want to argue this. I have one judgment. My lord kindly hears the matter.
Yes, ma'am.
When you people will understand the procedure, we do not. Yes, call the next.
But affidavit opposition.
Keep it with you.
Your
Come on
lordship,
the next date and file.
your lordship, next day.
If the affidavit in opposition filed by the respondent be kept on record, learned advocate appearing for the appellant
Yes, your lordship.
is for extension of time to file the reply.
Yes, your lordship.
Let the reply be filed within a week after the vacation. It's the matter for further consideration. 2 weeks after the vacation.
Great.
Marot 11, Marot, I am for the appellant petitioner. But this is my affidavit, sir.
Schedule C.
I did prepare on way for phone number. But this is an application for injunction in connection with the probate proceedings, my lord. My proceeding was, my lord, dismissed, my lord, before the learned court below. Thereafter, my lord, this appeal has been filed.
What injunction here?
My lord, since I am in possession of the property, my lord, now the other side, my lord, the respondents, they are trying to disturb my possession. But they are not in possession of the property.
Transferring alienating and
Yes, ma'am.
You are in possession. Then what interim order you want?
My lord, now the private respondents are the my lord, private respondents, my lord, they are coming, my lord, and my lord, disturbing my possession, my lord.
Where have you stated
My lord, in
how they are disturbing?
yes, my lord, kindly see.
Mr. Mondal, you are for all.
No, my lord, for responder one. So for others are concerned, my lord, I am not.
You are
My lord, I have served all, my lord.
Respond number one.
only one. But brothers, all brothers.
Brothers.
ওরে বাবা,
The heirs of the brothers, my lord.
তো মজন আছে।
Probably that has not been stated, my lord, in the stay petition.
Pardon?
Probably that has not been stated in the stay petition. Lordship kindly consider.
Mr. Ganguly
My
just
lord.
now got the brief. So Mr. Ganguly coming from criminal court says that everything has been written.
No, no, not that.
where you have written that
My lord,
they are
I have
going
stated, my
to
lord. Kindly,
transfer.
yes, my lord. Kindly come
So
to,
any paragraph
my lord.
that they are going to transfer. In the pair portion and in the cost title you have stated, but in the body of the application,
my lord, this was filed, my lord.
Hmm.
My lord, if your lordship sees, my lord, the
This was in March 23.
23, my lord.
We will expedite the hearing. We
My
will
lord,
dispose of
kindly
your appeal.
expedite the hearing, my lord, as well as, my lord, to, my lord, maintain status quo, my lord, in the property itself.
We only say none of the parties shall alienate.
Yes, yes.
We will expedite the hearing.
My lord,
Right? Yeah.
status quo to be maintained, my
No
lord.
status quo.
My lord,
Not to
same thing, my
alienate.
lord. My lord, same thing, my lord.
Can 1 of 2023. This application has been
মামলাটা hearing
filed paying for injunction. ঠিক আছে? Paying for injunction. Stop, Mr. Ganguly, learned advocate appearing for the appellant applicant submits that in the present appeal, the appellant has raised some substantial question of law, which law and fact, ঠিক আছে, which require decision on merits, and he submits unless the interim order as sought for is granted, appellant shall suffer irreversible loss and injury. Stop. He submits that the respondents are going to take steps to alienate the suit property in favor of the stranger. Stop. Acha. Mr. Such and such, Mr. Mondal, learned advocate, denies and disputes such contention.
Appearing for the respondent number.
Appearing for the respondent number 1, denies and disputes such contention. Stop. Hard the learned advocate peruse the materials on records. Stop. Prima facie an arguable case has been made out. Unless an interim and appropriate interim order is passed, the appellant shall suffer substantial loss to the of in view thereof. Both the respondents. In view thereof, we are inclined to direct the respondents not to create any third party interest. We direct the respondents not to create third party interest in the suit property in any way or manner whatsoever till the disposal of the appeal.
Application
Disposed of. Let the hearing of the application be expedited. Requisite
within.
Is your advocate on record?
My lord, my learned junior Obinobata. My lord, both parties may be directed, my lord. Paper book there you want? Oh,
No, both parties may be directed to maintain.
He can sell.
How he
Lord,
can say?
he
He
can
is
say,
saying that he is in possession.
yes, I am in possession.
Title is lying with you. You
But-
can sell it.
My lord, it is a dispute between two brothers. My lord, my lord,
ঠিক আছে, the
both the
parties এখানে হলো thereof we direct the
my lord,
parties
status
not
could be
to
the
create.
appropriate, my lord, situation, my lord, which will, my lord, which can ease either of the parties.
Yes, what do you say?
What do you
My
say?
lord, status quo, my lord,
Status
the
quo
order,
declaring possession,
the
my lord.
order, my lord, which has already been passed, I think that will be the proper. If the parties, my lord, are injuncted from, my lord, transferring this will be proper. But they should not disturb each other's possession, my lord. Lord, my lord, kindly grant me that leave, my lord.
That is always with you. Proper application file and come. Don't it-
Mr. Obinova Sachan entered appearance on behalf of respondent number 1. Service of notice of appeal upon the respondent number 1 is dispensed with. Put in.
Application disposed of Bapital.
My lord, expediting the appeal.
Let the hearing of the appeal be expedited. Respondent number 1 appearance there.
Dispensed with.
Requisites to be put in for service of notice of appeal upon the remaining respondents within a week after the vacation.
The vacation.
LCR cost to be deposited week after, informal paper books, liberty to mention.
Deeply obliged.
শুধু এভিডেন্স সার্ভিস ফাইল বি কেপ্ট অন Yes,
Keep your
next.
My lord, make a short passover.
I make paper for the respondent, my lord.
And for the appellant, make a short passover, Mr.
What is
De.
the application?
Application for stay of operation of judgment and decree passed by the learned court below.
In partition suit?
No, my lord, it's suit for specific performance. Total consideration amount was 2,20,000. We've already paid 2,10,000. Subsequently, 10,000 was the balance consideration amount. We preferred a suit for specific performance that has been decreed. And against that, my lord, they have come before this court. There's no prayer for stay in the stay application itself, my lord. I pointed out on the last occasion, my lord.
You have filed your
Opposition and reply has been filed, my lord.
All right. Pass over. Come. Ask your senior to come.
I'm good.
Please wait for pass. Yes, we do.
Yes, my lord, I am for the appellant.
My lord, I'm for the respondent, my lord, your lordship, the matter was listed for hearing on 11th, my lord.
13.
13, 14.
Yes, what happened?
My lord, the matter was listed for hearing on 11th of May. My lord, I was not there. Your lordship asked me to appear because there was a miscommunication because the learned advocate on record told me that he'll be asking for extension of the filing the affidavit opposition. But I found, my lord, he has met with that accident and he has collarbone has been broken. Therefore, he has been asked to stay in the bed rest for 2 months. Now, my lord, what I thought as your lordship directed me to appear, my lord, I have appeared before your lordship. Now, without
Orkodev Bishas.
Orkodev Bishas.
He met with an accident.
And his collarbone has broken on that particular date, on 11th. That is the reason he was coming to court, and this is the.
What is the suit for?
And the suit, my lord, I tell you, lordship, my lord, this is first suit is a suit for partition.
First suit.
Title suit number 30. That is the first suit
For partition.
Partition.
You are the plaintiff.
My lord, I'm the plaintiff. 1/3 share has been declared. This is a family dwelling house. Different number 1 and 2 is one is the other brother and 2 is the sister. The plaintiff, different number 1 and 2 did not appear. Contest. The
Plaintiff.
The different number 3, that is the sister, did not contest. Now, my lord, your lordship, the court has found that the suit property is the absolute owner. Hon'ble was the owner of the property, and court granted a decree for preliminary decree. 1/3 share was declared in favor of the plaintiff. Now, challenging that, and there was another suit, my lord, filed on behalf of my clients, my lord, that they have in a counterclaim. They have said that the suit property has been sold by the plaintiff and the different number 1, the sister, in favor of my underfence client. On taking a valuable consideration, and the court, the different number 2, there is the minor daughter has become the absolute owner of the property. The court disbelieved the counterclaim and dismissed the counterclaim. The 2 appeals were preferred without preferring any appeal against the counterclaim. Therefore, they have accepted the fact that the suit property is the joint family property. Therefore, there is no impediment if your lordship can direct the commissioner that has been appointed to proceed with the commissioner work, and the suit may be expedited. That was my submission before your lordship on that particular day.
No, my lord, actually, this property belongs to one Bono Bihari Mondal, being the grandfather of the appellant. My lord, he made an will. According to that will, this suit schedule property is unpartitionable. And therefore, this property
Will
belongs.
was probated.
Yes, the suit has been probated. Subsequently, his sons and daughters equally got this property, and other
What
sons and
injunction you are wanting?
Stay of the operation.
stay of the operation of the execution proceeding in respect of partition suit.
No execution process.
Execution has been
Execution,
started.
final degree has not been passed.
Final degree has not yet
Preliminary
been passed.
degree,
Commission
appeal
work,
So we
etc.
will say commission work will continue, no final degree.
Yes, without the leave of the court.
And another suit, my lord, this is 369 of 2022.
Pardon?
In item number 13, my lord. It's for a declaratory suit.
13 and 14.
They have filed this suit for seeking declaration of cancellation of the deed.
This is you are the appellant.
In both the suit, I am the
No, this suit was filed by
My client.
filed by
the respondent. You are the defendant in the suit.
I am the defendant in that suit.
I was the defendant in both the suits.
So this is a suit for partition.
Partition.
363 declaration, sir.
This is
No,
for
partition.
FAT 369.
It is, my lord, for declaration.
369 is for declaration.
369 of 2022 is for partition.
Yeah, let us check up.
You'll have to kindly check it up. Subject to correction by you.
No, 369 from 32.
No, it's true. 222 টা partition. এটা হচ্ছে declaration. 32 declaration. আমি 31
369 টা partition. এটা টাইটেল সুট 31.
দেখে নি, আমি দেখে
দেখুন একদম
আমি দেখে নি, আমি ভুলও হতে পারে।
31 দীপক মন্ডল ফাইল করেছে গৌতম মন্ডল এবং তাপসী সাহার এগেইনস্টে। দুটো করেছে, আবার একটা দীপক মন্ডল ডিক্লারেশন চেয়েছে, দুটোই দীপক মন্ডল ফাইল করেছে।
Which is the prior suit? Your partition suit?
Partition suit is prior suit.
Partition suit to prior suit.
32 of 2013.
32 of 2013 is the latter suit, my lord. It is for the declaration.
Then why you are saying then FAT 369 is on the declaratory suit?
Yes, my lord. 369 is for the declaratory suit. Decree for declaration was sought for in title suit number 32 of 2013, my lord, and challenging this, I have preferred this appeal, my lord. It is 369 FAT.
So what was the order passed? 1/6 share was declared.
One third.
my lord.
One third.
1/3 was declared.
Declared in partition suit.
And directed the commissioner to be appointed.
Acha, this is the partition suit.
Ah.
এবার পরের ফাইলটা দাও।
So for declaration that has been allowed, holding that the power of attorney granted in favor of the defendant number 1 is a forced document, has not been acted upon because no consideration money flowed in terms of
My
section
lord,
54 of
this allegation has not yet been proved in the criminal court.
No, I'm just saying the finding of the learned trial judge, the finding.
In this suit, what injunction you want? In this title suit 32 of 2013,
Yes, my lord.
it is declared power of attorney in such a not binding upon plaintiff have and defendants have no right to enforce act upon the same. So in this case,
We
what
have no-
injunction you want?
Nothing.
Nothing.
My lord, they are seeking the declaratory decree that the deed itself is not binding upon them. But by virtue of this deed, my lord, myself transferred share
We are
in
subject
favor of
matter
my daughter.
Very good. Now, what injunction you are wanting? What is your apprehension? This is simply a declaration that power of attorney is not binding.
There was a stay of the operation of this order, my lord.
Why you are asking for stay?
Because, my lord,
What they will execute in this suit?
my lord,
What execution case they will file? Tell us.
at present, my lord, my daughter is the owner of the property.
That was disbelieved by the court below. On the basis of
They lodged a complaint, my lord, and on the basis of that complaint, a criminal case has been initiated.
a blank paper has been converted into a power of attorney.
No, my lord,
Property was sold transferred
it
in
is
favor
their
of
case,
the
but
daughter.
they have received the money from me.
Well,
By
but
signing
you
the
see the
money receipt, my
finding,
lord.
the court said no.
We are not on that. We will say that the partition commissioner has been appointed. He will continue with the commissioner work, but no final decree will pass. It
Grateful.
is pertaining to the same property.
Yes, my
So if the final degree is not passed, all your rights stands protected here. We will hear the appeal.
Yes.
Yes, sir.
Until হয়ে যাবে আপনার তবে তো অ্যাপিল আপনি বলতে পারবেন না।
একটা ডিক্লেরেশন চেয়ে ওই যে ইয়েটা মানে সেটা চাইতে পারতো, দুটো করে দিয়েছে।
Mr. Ghosh, why two separate suits?
But two
It
suits
would have
were
been-
filed. Two suits were filed. I do not know on that
Have
particular.
been on the same suit itself.
Yes, it could have done, my lord. I do not know. This is a suit under section 31 what specifically for cancellation of deed, power of attorney. But the same, my lord, your lordship knows that when a deed is executed, the proper remedy is to file a suit under section 31 for cancellation. For that reason, possible why the adverse of the trial court lawyer.
Filed the suit seeking that declaration that the
deed is not binding upon them.
Lordship, that was the prayer.
Yes,
It
sir.
could have been done in the first suit itself.
ঠিক আছে, আচ্ছা এই অর্ডারটা
অর্ডারটা দুটো একসাথে করে দেবেন। FAT 369
369 of 2022 and
370 of 22
আচ্ছা উইথ ক্যান এটা করবেন and এটা and দিয়ে এটা উইথ ওইটা।
আর দুটোতেই অ্যাপেলেন্ট হচ্ছে মিস্টার সাগরময় ঘোষ আর দুটোতেই রেসপন্ডেন্ট হচ্ছে শিবাশিস ঘোষ। ইউ আর সাগরময় ঘোষ।
Yes,
এটা পোস্ট টাইটেল
অ্যাপ্লিকেশন গুলো দিচ্ছিলেন কোনটা কিছু
হ্যাঁ
my lord, I am the respondent number 1.
দিচ্ছি, কিন্তু কোন অ্যাপ্লিকেশনটা কিসের জন্য ফাইল হয়েছে এটাও স্টেজ আছে, ওটাও স্টেজ আছে। হাত জ্বালানো
দুটোই ডিসপোজ অফ করে দেবে।
আচ্ছা ঠিক আছে, হ্যাঁ তাহলে এমনি আচ্ছা আচ্ছা FAT 369 of 2022 have been filed
challenging the judgment and decree dated 29 September 2022 passed by the learned civil judge senior division bracketed additional court Pupli at Chichura in title suit number 32 of 2013
and তাই তো ওইটা 32 না 31
369 টা হচ্ছে টাইটেল সুট 32
369 title suit 32
Yes.
আচ্ছা and FAT 370 has been filed
by the same judgment and decree disposed of.
Yes, on the common judgment.
আর পরেরটা ওইটা চ্যালেঞ্জিং দি সেম জাজমেন্ট এন্ড ডিক্রি another appeal being FAT
নাহলে এইভাবে বললে হয়। আচ্ছা আমি কেটে দিচ্ছি by common judgment
Both the suits were heard analogous.
আচ্ছা common judgment agreed both the suits being title suit number 31 of 2013 and 32 of 2013 comma which were heard analogously comma were disposed of. Were disposed of by passing decree in title suit number 31 of 2023
31 2013.
dismissing the counter claim filed in connection thereto and
My lord, 2013.
dismissing the suit
2013
It was said 2023. That is it.
dismissing the suit being
the common judgment and decree passed by learned civil judge senior division title suit number eto and eto were disposed of. Where does the counter claim come, Mr. Ghosh?
Yes, your lordship kindly find those judgments. The counterclaim was dismissed.
31.
31.
কোথায় কাউন্টার ক্লেম
মানে issue number 9 paragraph internal page 12.
In the operative portion, where do we find counter claim dismissed? Counter claim 5 items dismissed.
Yes, page 13.
counter claim dismissed.
আরেকবার দিয়ে দাও।
আচ্ছা
My ordering portion counterclaim is dismissed.
আচ্ছা by a common judgment and decree আচ্ছা both the suit
Dated eto passed by Sachin sir.
dated 29th September 2022, both the suits being title suit number 31 and title suit number 32 of 2013 are disposed of.
claim filed in title suit.
আচ্ছা
31 was
title suit number 31 of 2023, which was a suit for partition, was decreed in preliminary form, and the counterclaim filed in connection thereto was dismissed. ঠিক আছে? And title suit number 32, in which one declaration to the effect that the power of attorney and the deed of sale by number 289 of 2023 is not binding upon the plaintiff was dismissed. The appellant, being the defendant,
being the defendant number.
Being the defendant number one in both the suits, has assailed the judgment and degree by filing two separate appeals, being FAT 369 of 2023 and
22, my lord.
22 and FAT number 370 of 2020. So, during course of hearing,
Is appearing for the respective party.
are the learned advocate appearing for the respective parties, and we are informed that
That in the partition commission, and we have been informed that if that a partition commissioner had already been appointed.
মানে order has been passed.
Huh?
Order has been passed. Not yet been appointed.
Not appointed.
Appointed, but order has been passed. But
Last occasion,
we shall be taking steps for appointment of partition.
last occasion, there was an adjournment in court below.
for appointment.
As per my
The application to allow হয়ে গেছে।
Yeah, hello.
On the last occasion, there, as per my instruction, my lord, on the last occasion, there was an
We are
adjournment.
writing it in this manner. We have been informed that an application for appointment of partition commissioner has already been filed.
Yes.
In view thereof.
In view thereof, in the event the partition commissioner is appointed, the commissioner work shall continue, however, no final degree shall be passed without leave of the court. The parties are directed to maintain status quo with regards to the nature, character, and possession of the suit property as on date till the disposal of the appeal. Both the application being such and such are disposed of. Let the
Shall be hard analogously and
both the appeals shall be heard analogously. Let the hearings of the appeals is be expedited. With 2 weeks.
And my lord,
Court requisite
LCR to be
or
called for.
requisite cannot. You are appearing for all the respondents.
Respond on one.
Respondent number one. Your advocate on name of your advocate on record.
My lord, Orkodev Bishwas.
Orkodev Bishwas.
Orkodev Bishwas.
Orkodev Bishwas enter appearance on behalf of respondent number one. Service of notice of appeal upon respondent number one is dispensed with. They stay হবে 2 weeks after the vacation. Requisite. That's a lower court records.
একটা প্যারা লিখে দেবে as filing of paper books in the other application.
Filing of the paper book in other appeals is dispensed with.
We are dispensing with the filing of paper book in the other appeal.
Lordship.
We have directed both will be heard together
Lordship.
and put in your requisites for service within a week after the vacation. Put in the LCR cost also within week after the vacation.
Combine paper.
দেখে নিও যেটা
ঠিক আছে।
পেন ড্রাইভে মাইলট দেখে যদি কিছু মিস হয়ে থাকে
And I am grateful, my lord.
পাসওয়ার্ড হয়ে রয়েছে ওটা ডাকো তো
nine.
Yes, Mr. Roy, why you are not settling the matter?
Why?
She is inclined. She is saying that her client is inclined to do it. The
But
matter of 3
My
lakhs.
lord, can you consider my petty comment, my lord? I've informed my client that whether it is your daughter-in-law and your grandchild, you should settle it out of court. He said, it is your father who have allowed me to win this case. You do not say all these things. I want to fight this litigation. What more? That's, I'm in soup.
So your client will not do.
My client.
Your client will not settle.
Then why you are not filing? She is so interested. Why she is not filing the opposition?
See, she's not coming there.
Huh?
Only telephone.
Then you don't appear in the matter.
Only one, that is the thing.
Your juniors come and repeatedly pray for extension of time.
Because they say, today we'll come, today I'll come. After that, my lord can dispose of the application, my lord. I'll not.
Yes. What is the use of keeping the application?
Application to
For stay of the
or stay of the
execution in a money suit.
execution case has been filed. Money execution case.
Yes, sir. 5 of 16, execution case number 5 of 2016.
চলে বলছে 70 বছর বুড়ি কিছু বললে বলছে যে তোমার বাবা কিছু
Execution case to stay করতে হবে.
Now LCR has come. You have not filed Tolovana requisites and everything. Maybe কিছুতে interested. Valuation statement differs there. Defect আছে দেখছেন? এটা আরেকটা ফাইল কোথায়?
We are continuing defendant number 1 and 4 appellate and Vibhavati
one.
1.
2 or 3.
2 and 3 and the bank. Bank I have already sent the letter and notice and as a lordship direction.
Certified coverage came back after on perusal. Corrections are found to be correct. Paper book you have not filed. LCR has come. It was not heard earlier.
Earlier option, my lord, only.
Is the desire of this court, my lord, the matter can be settled out of court. So this sort of
Yes.
that is the only desire of this court.
Then what can be done? It has to be regular.
It is something else because the I am.
Last chance your lordship with client, his client, my lord, to settle up the matter. Otherwise, my lord.
He has stated in so many words. What more do you want?
Yes, I've heard.
And anything I say is your father. What I do. And one illustration he has given, my lord, I cannot oppose that. You are inheriting your estate of your father, so it is your duty to look after my case. 70 years old lady, my lord, I cannot say anything in open court more than this.
Grandchild also there.
কি বলবো বলছে তুই বাবার সম্পত্তি পেয়েছে তুমি মামলা চালাও
সেটাই
ভালো কথা
How long this will continue? We will regularize the
appeal, my lord.
দিয়ে দাও.
Because only the plaintiff, my junior is appearing. That's why, my lord, I am submitting whatever lordship.
When there is no chance of settlement,
There is something, my lord, which the son died. It is the belief of the plaintiff that is due
now
to the
money is lying with the bank. Dena Bank. CHAKRABORTY.
If my lord wants, my lord can also direct them to withdraw their 2/3 share. Because apparently they are entitled to get 2/3 share. Being the daughter and the wife, they are admittedly entitled to get 2/3 share of the entire estate of the disease. At best, mother can inherit 1/3, not more than that.
Maybe 1/3.
What injunction you have prayed for?
Stay.
Execution case, stay of all further proceeding, money execution case number 5 of 2016.
5 of 2016.
Yes, my lord.
ডাইরেকশনটা দিয়েছে ইয়ের ওপর মানে এনাদের ওপর
আমি জানি না দিদি।
Instance, who was the plaintiff?
The respondent number 1, the
Bhavati.
Bhavati.
His mother. Mother filed against Purnima and Payal.
Yes, the daughter and the daughter-in-law.
That claiming is a money suit.
Yes. Estate of the disease, my lord.
The same is decreed against the experty again. Oh, you are the daughter and the widow did not challenge, did not contest.
Yes.
Instance which is decreed on contest against defendant numbers 1 and 4, experty against 2 and 3.
Yeah, 2 is the minor daughter because the mother has contested the defendant number 1.
ম্যানেজার
No.
1 and 4, mother and
1 and 4 হচ্ছে মাদার
Oh, 1 and 4 is mother and the bank.
Bank. Because the defendant number
সমস্যা সমাধানে যদি 1/3 ওই ইয়েকে
Plaintiff does get a decree to the tune of rupees 3 lakh. মাকে দিয়েছে 3 lakh টাকা আর
3 লাখ টাকা তা
make payment within 3 months.
no total amount
that is not ascertainable because the LIC policy, my lord, it is up to 3 LIC policies are there, my lord. The particulars has been given, my lord. If your lordship may kindly consider the
Total amount.
the some assured value is there, my lord, but what is the maturity amount that is not asset.
the LIC
Policy, the
document have been executed most probably.
Yes, the the value of the LIC policy has been, but after death, what will be the actual amount that is, my lord, will find in the degree. Amount কোনো জায়গায় ইয়ে নেই।
নিচে যাবে
7,26,000.
oh patent money suit valued at 7,26,690 out of which the court directed you
3
to
lakhs.
pay 3 lakh 26,000
So remaining money is
She is entitled to get. Because apart from one that this respondent 1 is not entitled to get anything because her claim is restricted to 1/3.
No, you are sure that the total claim is 7 lakhs and odd.
Yes, from the degree itself, my lord. From the degree itself, my lord, I am finding.
Degree for Mokuddama Mul Vivadi Nikot হইতে
বাদীর পুত্রের ওয়ারিশ ক্রমে 26,690 টাকা পাওনা সাব্যস্তে
আদায় দেওয়ার ডিগ্রি।
So that is lying with LIC. LIC policy was matured. The person died.
My lord,
Now
death maturity.
That maturity value has been deposited.
No,
in the bank.
that has not been deposited. That has not been ascertained on that ground. It is the amount which is the policy has been
payable.
Due and payable.
7
Normally, it will be
lakhs.
added by some other components are there, my lord. I do not have any instruction.
The money must be lying somewhere.
Yes, but that is that
Otherwise-
instruction I do not have any under in which account or what form this money is there, whether it is still in the.
When you say very good, mother is entitled to 1/3.
Apart from that, nothing.
So all right.
Not more than that is the amount has been now, my lord,
Now
disclosed.
it
Nothing
is
more
lying
than that.
with whom? It is lying with
That
whom?
is the
We have to direct, that
Yes.
money should be paid.
in the bank has been. That's why your lordship is to.
Execution case has been filed.
Yes.
What is the state of that execution? Where is your execution case, that decree form? How much you have claimed?
Yes, the tabular statement is with me, my lord.
It is with you. That is 3 lakh something.
Yes.
Now it is lying with whom?
My instruction is lying with the bank. My instruction lying with the bank.
Yes. Total is 14 lakhs. My lord, may I 10,553,238. My lord, may I hand over a tabular statement to your lordship, my lord?
No, not required. What is the
no interest direction for payment of interest.
Interest.
Given.
It was
You have calculated interest.
that include, recovery of money, 3,26,079 rupees. এবং তদুপরি সুদ, my lord. Even if, my lord, it is a matter between the daughter-in-law and the mother-in-law fighting with the ego. Nothing more than that. বক্তব্য আমার ছেলেকে মেরে দিয়েছে। এর কিছু মানে উত্তর নেই আমার কাছে।
কেউই পাবেন না। টাকাটা তো তুলে নিয়ে বসে ব্যাংকে থেকে।
ডিজিটাল পোর্শনে টাকাটা যে ওটা সেটার ব্যাপারে কিছু সেপারেট এক্সিকিউশন।
Actually, will you be able to disclose before us where the money is lying now? In whose account? Whether it is interest bearing account or not?
দেখুন দিদি,
That's why now last
না,
question your lordship.
দিদি আপনাকে আপনি হেল্প করতে পারি, আমার কাছে আছে দুটো লাইফ ইন্স্যুরেন্স এর পলিসি নাম্বার গুলো আছে আর ম্যাচ বেনিফিট গুলো আছে, কিন্তু আমার মক্কেল কোনো ইয়ে করছে না, কিছু হলে বলছে আমার ছেলেকে মেরে দিয়েছে। This amount with the matured amount of LIC, it is not directly credited to any bank account. No. It may be so that the money was total money has maturity value is 7 lakh and odd. Then there must have been some sort of understanding that the money should be kept in this Dena bank. Otherwise, why the bank has been impleted? Must be some state.
আমি এইগুলো আপনাকে দিচ্ছি।
You have to read the judgment, na, if it is given there.
না
You have to show us that, Mr. Sarkar.
ওটা কিছু বলা নেই মেলা।
Oh no, it's
Must have been stated. There was a solenama, etc., etc. Further parties, solenama, defendants of this would understand.
No, you received the entire money. Defendant number 1 had received the entire money. Court has. It was your case, Mr. Ray's client's case. That you received entire money of 2 policies, 5 separate checks, and deposited the savings bank account maintained in Dena Bank, maintained with Dena Bank. The LIC have already issued the check. Now the amount has been kept in Dena Bank.
Then I shall serve, my lord. I have already served Dena Bank.
Dena Bank, the account is being maintained.
টোটাল অ্যামাউন্ট কত হচ্ছে জজসাকে বলে জজসাহেব সে মতো অ্যাপোর্শনমেন্ট করে দিতে আর কি। আপনার অ্যাকাউন্টে আছে,
you give the details.
তাহলে আমার তো 130 উপর ক্লেম হতে পারে না।
LIC money matured, kept in the bank account. Who gave? Now we are not concerned. He kept in the bank. So we need to, for solving the problem, we can ask the Dena Bank that you disburse 3 lakhs and odd along with the accrued interest in your favor, and you keep the remaining amount in an
Interest bearing account.
Appeal will be admitted, it will be heard. Whether to that 2/3 you are entitled to anything or not, that will be the subject matter in the appeal, because it is their appeal. They are saying they are not satisfied. They want the entire money.
It is their appeal. I am claiming 1/3. I am not entitled to get more than that.
It has been filed by
Purnima, the
widow.
Daughter-in-law.
widow and her daughter.
Yes.
So being respondent number 1, I am the mother-in-law. In any event, I am not entitled to get more than 1/3. My
You are
claim,
the respondent.
yes, respondent number 1. That is why, because whenever I asked this lady, my lord, she only. So at best, my claim cannot be more than 1/3 in any event. Now, whether she will get his entirety or not, that is the dispute.
To ask your client to ascertain from the
What is
bank
the amount?
what is the amount, what is the account number. Ask the branch manager to give you the statement of that account. Everything you will get.
Another suit was filed in between
Yes,
the
previous
190 of 2005.
That is a
That
compromise.
was ended in a compromise.
Compromise. Well, against.
Where is the solenama?
My point is that against the solemn.
In that, the money deposited in the bank would be disbursed in favor of dependent number 1 and 4. and plaintiff relinquish her entire claim in lieu of rupees 1,75,000.
তারপর মনে হয় ওটা দেওয়া হয়নি।
Well, my contention is that against the compromise order, this suit is not pensionable.
সে তো পরে
Yes, for it.
আগে আপনি কিছু পান আপনার মেয়ে আপনি আর আপনার মেয়ে
By the order of the court, defendant have already withdrawn 7 lakhs. You have withdrawn 7 lakhs.
সবই please go through the judgment. Let's go through the judgment.
That is their case, my lord. That is their case and finding. That's why, my lord, I may prefer this appeal. Well, I shall, my lord, the 2 weeks after
আমার অবস্থা চলছে।
uh,
Yes, call the next one.
my lord, let this matter, my lord, at present, my lord, I do not know, my lord. I shall take instruction, my lord, obviously, my lord, because, my lord, as your lordship direction, my lord.
এটা we are trying to help you out. We are trying to help you out so that the matter
In
can.
1 week after vacation.
Yes. কি শরীর শেষ হয়ে
I'm grateful to your lordship.
Any judgment.
very good.
My lord, I behalf of appear on behalf of the appellants, my lord. Lord, this appeal is filed against the challenging the order passed by city court, my lord. The probate application was dismissed, my lord. Probate application, my lord.
Have you served the application?
My lord, it was solved, my lord.
হয়েছে আরেকটা পাসওয়ার্ড ওটা দিয়ে দে। First time it is coming.
My lord.
First time it is coming.
My
ये तो देखो কোনো ডিফেক্ট নেই। Appellant is directed to serve the copies of the application being Can 1 of 2022 upon the respondent. ঠিক আছে? Upon the respondents, intimating that the matter shall appear, shall be taken up for hearing for further consideration on 19 June. And to file affidavit service on the returnable date.
Is the matter according.
Please the matter according.
19
June.
Let the status quo be maintained. Status quo be maintained, my lord.
Couldn't follow.
Let the status quo be maintained, my lord. Let the nature.
What status quo?
What status?
Well, let the
You have
my lord can
fought for an order to restrain the respondent from transferring or alienating.
You are the petitioner.
my lord, I'm the petitioner in this application, my lord.
Who filed the probate application?
My lord, the testator he died bachelor, my lord. So
Your probate case was dismissed.
my lord.
No, it to Gita.
The probate was granted
Granted to Gita, my lord.
to
He's the niece.
probate was granted.
He's the niece of the testator.
You are for the respondent in the appeal.
No, my lord.
No, ওই জন্য এসছে, ওই জন্য গৌতম
The appellant.
ঘোষ বোধহয়।
You are for the appellants.
Appellant,
Gautam Ghosh.
Gautam Ghosh.
appellants অনেকগুলো আছে।
গৌতম ছিল respondent.
গৌতম ছিল ওখানে ডিপেন্ডেন্ট।
Why there is a miscase? Accordingly, applying correction of the ordering portion. What have you stated in your application?
Time to transfer. Hello.
Where have you stated?
I file can 1.
It is a landed building.
Yes, my
Any
lord.
construction stands on the
Two-story building, my lord.
and who are all parties are residing there.
My lord, Gita is not residing, my lord.
Gita is not
Gita is not residing.
So Gautam and others are occupying the property.
My lord. Gautam, Shankari and Ila.
Where have you stated that in your application? That you are not in the property, they are occupying and they are inclined to sell the property. Where have you given? Petitioner applicant কেন বলছে গীতাকে দিয়েছে?
Who is Gita?
Gita is a niece of Anil Kumar, niece of Anil Kumar Ghosh.
Niece of Anil Kumar Ghosh. What's the name of the testator?
Anil Kumar Ghosh.
Anil Kumar Ghosh. A property belonged to Anil Kumar Ghosh.
My lord.
And Gautam Ghosh. Relation between Anil Kumar and Gautam?
Nephew. He died bachelor, my lord. These are all nieces and nephews of Anil Kumar Ghosh.
The testator died bachelor.
My lord.
Oh. Gita is a daughter of one brother.
One brother.
And Gautam is the sons of another brother. Oh.
Where have you stated in the judgment that who is occupying the house property? Any statement is there?
No, my lord.
In the petition, did you get any interim order?
No, my lord.
You have not served, no?
Well, it has been served, my lord.
Where is your affidavit service?
Affidavit is not.
Huh?
It's not with me.
Come tomorrow. Come tomorrow with your affidavit of service.
We shall see. We have to see. It's a big bird. Not value.
Madam, service is complete, madam.
Yes.
Service is complete, madam. The affidavit is not prepared.
Prepared the affidavit day after tomorrow.
Good.
I am got the appellant.
For the respondent plaintiff.
Leave me be granted to file and supplementary affidavit in regards to the pair portion of the stay application. And I'm grateful to me, my learned friend on the last occasion indicated. regarding payer portion of the stay application. The
Shall not be
this
set
is the
aside.
base specific performance of contract, suit for specific performance of contract. But I am for the dependent in the trial court,
Swapnapal,
Shopnapal. But
you are the appellant.
I am for the appellant. Degree is passed in favor of my learned friend clients. But against that, this appeal has been papered. But the main contention is that this agreement, my learned friend taken plea that this is the agreement for sale. My client is taken that this is a loan agreement. And that on
What agreement?
loan agreement, loan agreement.
Loan.
And the
My lord. At 16 of my opposition, my lord.
30 page 34 also.
34 of there, my lord.
Your advocate's letter.
well, that advocate later, my lord, after that, when she came to learn regarding that this is the caption, that is the agreement for sale. The loan agreement, that is the caption, that is the agreement for sale. On the basis of that, the landlord advocate sent said notice, but that is not admission.
Well, that is admission enough
Well,
since there
the
was no amount of
main
loan.
contention of the appellant is that the before the trial, the agreement has been sent to the impound, predetermined. The learned judge passed the impugned order.
Hello, with regard to impound, that order has attained finality. They have challenged that order. My lord, may I challenge that order in a 227 jurisdiction before this court. My lord, Justice Basu was pleased to dismiss the application on hold since the document is unstamped. It has to be impounded and the nature of the document will be proved during trial. That order is annexed itself. Also.
Yes, that order is annexed, but
And they have not challenged any special.
when that agreement sent to the impoundment, before trial or after trial. This is so one of the Supreme Court judgment is that will be at the time of before passing the judgment, but after trial. But learned judge predetermined that this is the agreement for sale. On the basis of that, sent to the collector to impound.
Unless it is stamped, it can be adduced as an evidence. It has to be stamped. After that, it can be adduced as an evidence.
Firstly, that's a trial would be completed, and that learned judge will be came to the conclusion this is the loan agreement for sale, then sent to the impound.
My lord,
now at this stage, I am paying to stay the impugned.
my lord, kindly comes to page 57.
That is a loan agreement. And then you are saying that it is required to be impounded.
My lord, kindly comes to page 57 for once. That is the order passed by this court, my lord. Their revisional application. The operating portion is page 58, second paragraph. May I read, my lord? The second paragraph, the document specific performance of which the plaintiff is seeking in the suit is not sufficiently stamped. The nature of the document shall be decided in course of the trial of the suit, which has no nexus to the assessment of the actual stamp duty payable on the said document. The document on payment of proper stamp duty becomes admissible, and such payment ipso facto does not dispense with the requirement of proving it according with law. It had to be done before trial, otherwise it could not have been given a native evidence. And they have challenged that order, civil revision dismissed. They have not preferred any special litigation before the apex court. Attained finality, my lord. Regardless, they have not reduced any evidence with regard to their claim either.
That effect, what is the observation of the court below?
My lord, kindly comes to
Decree was passed on
decree,
this revisional order April 2022.
my lord, the order of sending the document to the impound is at page 50, my lord.
Then what happened?
It was sent, my lord, kindly comes to page 54 once.
So tell us what happened.
If it is sent for impound, penalty and the stamp duty was assessed, and I was directed to pay it. But that has been recorded in the order, my lord. My lord, page 50 is the order dated order number 18 passed by the court below.
Page 15.
Page 50 of the stay application, my lord, of their stay application.
So ultimately impounded
My lord,
with penalty.
my lord. Subsequently, it reduced as evidence as it should be.
Treated as a agreement for sale.
Hmm?
Treated as a agreement for sale.
It was
This
a
is my
bind.
objection. Against that, I prepare a revisional application. Well, revisional court
Not decide in your
India did not decide anything.
How your contention that it is a loan agreement survive? How does it survive now, Mr. Dotto?
Because before trial, the agreement.
The only ground was that this is an insufficiently stamped document. This was raised, court said you impound. That impounding was done.
When my question is
Trial that was taken into.
yes, that in before trial, if the document sent to the impoundment, that means predetermined by the learned trial court. This is that may be impoundment after the trial and before passing the judgment. This is the contention of the Supreme Court. If you
Issues were framed.
no, before that, only on the basis of the application made by learned clients, matter will be sent to the impound and treated as a agreement for sale. This is not a
It may be sent for impound soon.
When was the suit filed?
The court itself.
Suit was filed on 23rd of June 2010.
Itself accepted, treated the document instrument as a agreement for sale.
Suit filed on 23rd June.
Impound করে দিয়েছে।
It was a loan agreement.
লোন এগ্রিমেন্ট এখন এসে
No, issue frame it was the- issue frame it was- Where is your written statement? Where is your written statement you have with you?
My
Page 21, my lord, of the stay application,
I see.
You from the
along with counterclaim.
from the body of your written statement, you state, you show us that you took this point in your written statement.
My lord,
In your written statement, you took the point that it was a loan agreement.
yes,
In your written statement, show us.
That is there.
Show us.
সাক্ষী হয়েছে?
হ্যাঁ, সাক্ষীটা কি হয়েছে?
the fact is that this is the page 23. On or about 19th of 2009, son of the defendant of the part that during special guard that during the proclamation medical treatment, while the defendant meet the cost of the medical treatment of 20 more the contact the and the relation listen the dependent private loan. The dependent assured to arrange private loan on interest from the one of the well-known person so Mr. Sanjeev Malik, which is the page, paragraph 7A. And the plaintiff herein on the same date, not reasonable. Document PM 4 PM, the said Guru Bhai brought to the plaintiff to the house of the defendant.
Cannot read this.
But it's a type copy to that.
All the evidence is also on record.
Everything, along with depositions, everything was on record.
So we will finally hear.
My lord.
You advance your arguments for paper book is not required.
Not required, please.
Just come tomorrow.
My lord.
Before vacation, my lord, matter will be hard, my lord, on to length, my
Before
lord.
vacation, you
Very well,
don't
very
do
well.
Only one thing, whether the instrument is a agreement for sale or loan.
All loaning. This is the only point.
Only point.
Only point.
Only point, my lord.
You show us your written statement. You
Yes.
show us your deposition. We dispose of the matter.
My lord, tomorrow, day after tomorrow. Tomorrow is
After tomorrow,
My lord, it's last penalty matter. My lord, kindly keeps it tomorrow, my lord. Otherwise, the matter could not be.
Tomorrow come. Read it today.
I'm grateful, my lord.
For us.
get to you.
For the appellant, my lord. And my lord, one appeal has not come, my lord. Two appeal was there, analogous hearing for.
what happened? Settlement?
Yes,
No,
so far I filed this application.
You filed.
Yes, just today I'm yet to copy the reach.
What is the number of the other appeal?
Oh,
261, my lord.
advance copy, my lord. I'm today
261,
affidavit is
261,
261.
261,
Very
up to
good.
2022.
The list out of two. So you have, you have put your signatures and everything.
I have not seen now, my lord.
Just the
But RAP I have seen and I have corrected. But later on, this 15 days later, he is filing, my lord.
Yes, yes.
Just for a moment, I have seen and I will
Yes,
file
yes.
after 2 p.m.
No,
No,
come
no.
tomorrow.
Come tomorrow. You will file today.
yes, my lord. Affidavit yesterday, affidavit has been.
No, whether it is in form of a joint application.
No. By our client filed joint affidavit filed these applications. Admitting what is the share in the plaint will be treated as a final. And my learned subject to correction, my learned friend also admitted that the plaint.
So under 12 rule 6, we
Yes.
have to dispose of
Yes, on that.
on admission.
On admission.
But the order has not passed according to averment of the plan. It has been passed as per schedule. For schedule, total property has been shown.
No, now your problem is
Yes,
solved.
if it is solved, my lord, I will
Let him file it today. You come back tomorrow and tell us, we dispose of it.
What happened?
mentioned, my lord, to be mentioned.
Quantum of the land has been mentioned, but he is entitled to 3 decibel out of 9 decibel.
Record his admission. What is
That is
The
that,
plaint itself.
that is why, my lord. Same thing. I'm also
you just
same thing.
ছাপিয়ে দিও না।
এই যত
To be mentioned according to
এইটা যে কোনো একটা আমাকে পাঠিয়ে দেবেন তো একটা কি বলে দুটো একটা করলেই দুটো ফ্ল্যাট এসে যাবে নাকি
দাদা আপনি একবার দেখে নিন যদি
হ্যাঁ।
কিছু-
ভালো
না এইটা
কি হবে, যখন হাসছে কেন?
Full terms in breakfast.
Now, it will appear under the heading to be mentioned, my lord. Last two occasion, my lord, it will appear under the heading to be mentioned, my lord.
ঠিক আছে।
তুমি মেনশন
ফাইল আসবে ইয়ে অ্যাপ্লিকেশন আসবে
নাহলে এটা দিয়ে দেবেন নাহলে এটা দিয়ে দেবেন
না
It will be reached. We don't have many applications.
My lord, there is a my lord, meditation from the Supreme Court, my lord, from 1:30 to thereafter, my lord. That is why, my lord, I am saying.
mediation.
My lord, tomorrow.
You are in meditation.
In mediation, my lord, from my client, a mediation will be held, my lord, from online, my lord, from 1:30 to thereafter, my lord.
Tomorrow.
My lord.
probably my lord today it will be filed, it will be not reached by evening. If it is not reached, then it will not be listed to, so it remain in the list. I'll be here, my lord, in the morning. If it is
So you file it.
Yes.
Give the number to my court officer.
As a question.
He will requisition it
And
and
day after tomorrow, it would be, yeah.
Yes.
Day after tomorrow.
Day after tomorrow, it will be benefit for everybody because he can also go through the application. itself.
tomorrow you have a mediation.
Mediation. Day after tomorrow, another hearing to be mentioned.
To mention.
To be mentioned day after tomorrow.
My lord, I am for the appellant, my lord, and the petitioner. My lord, may I file my affidavit of service?
এই জয়ন্ত এই
আরেকটা ওই
তুমি ওই অ্যাপ্লিকেশনটা দিয়ে রিকুইজিশনটা আনিয়ে নিও ওই অ্যাপ্লিকেশনটা সমেত
Of service, my lord. My lord, I have two applications. My lord, my first application is a section 5 application, my lord.
How many days do you get? 315 দিন। You have challenged the order passed under order 20 rule 12 for mean profit.
Yes, yes, your lordship. Yes. My lord, the judgment has been passed in December 2019. My lord, there has been delay, my lord. Due to the reason, my lord, I had actually filed a review application. My lord, instead of coming up in the first appeal.
five crore 78 lakhs 44,000.
Yes, 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 my lord, I am aggrieved because my lord, interest pendentility as well as my lord post-suit interest has not been granted.
Were not?
But not granted. My lord, only pre-suit interest had been filed, had been granted to me.
You are the plaintiff.
Yes, yes, I am the plaintiff.
No, why you are aggrieved by this order?
My lord, aggrieved because my lord, interest has not been granted. My lord, interest is an essential component of mean profits, my lord. My lord, I have been given interest only for the pre-suit period, not the pendentility interest as well as post-suit interest. That is, my lord, till the date of actual payment from the date of decree, my lord, I'm entitled to interest. That interest has not been given. My lord, today, my lord, first, my lord, I'm seeking admission. My lord, my delay to be condoned, my lord.
How many days delay?
My lord, according to my calculation, it is
15 days.
Yes, my lord, the department has reported 315.
But what stay do you want?
My lord, perhaps, my lord, the order is in my favor, my lord.
It has to be expedited.
Yes, essentially, yes. Yes, my lord, for the appeal hearing to be expedited.
There is no scope for any interim order. What you have prayed for in injunction?
My lord, I have not prayed for an injunction. My lord, I have prayed for an appropriate order, stay or appropriate order.
Now, how you have served upon all?
Yes, my lord, I have served upon all, but my lord, the predicament is, my lord, only Bharat Petroleum, respondent number 1, my lord, he is The company is only contesting the litigation before the learned court below as well. My lord, the other two respondents who were licensees in whose favor I had granted the lease, my lord, with the recovery of possession, my lord, they have left the premises and gone. Hence, my lord, my service could not be complete. My lord, I do not know their present address, but my lord, Bharat Petroleum had been contesting the
How can you get your present address now?
my lord, we do not have it. Hence, my lord, we've served upon Bharat Petroleum who has taken service.
এইখানে কি বলছে এদের উপর সার্ভিস খুঁজে পাইনি নাকি বলছে অ্যাড্রেস আমাদের ক্যারিং অন বিজনেস হ্যাঁ
They have
Left the
left the premises.
Yes, my lord, I have recovered possession. My suit was for recovery of possession and mean profits.
They were the lessees.
They were the lessees. My lord, they were running a petrol pump over there. My lord, in the name and style of
They were attached with Bharat Petroleum.
operating that petrol pump.
পেট্রোল পাম্পটা লিজ দিয়েছিল এদের
Where have you stated that they have left? You have recovered possession.
Yes, my lord, I have recovered possession by virtue of an order of this court.
What is your reason of delay?
My lord, my delay is because, my lord, I had filed a review application against this order. My lord, on the ground that there is error apparent on the face of record, interest ought to have been granted.
Then what happened?
My lord, of course, that has been dismissed. My lord, I should have filed an appeal instead of review. So, my lord, my entire time has been consumed in pursuing the review application. My lord, that review has finally been dismissed in December 2022. So, my lord, from March 2021, my lord, when my review application was admitted, till December 2022, my lord, the entire period. Yes, 2021. 31st March 2021, I had filed my review application. My lord, it had been dismissed on 16th December 2022. My lord, that entire period has been consumed because of the review application.
Then you filed the appeal on who is dead?
My lord, I have filed the appeal. My lord, 1st March 2023.
An order impugn was passed.
My lord, on 17th December 2019. My lord, COVID had also intervened in the meantime. However, my lord, after dismissal of the review application, of course, my lord, we are before your lordships.
Paragraph 16, what you have stated?
My lord, paragraph
16.
16. My lord, paragraph 16. My lord, my section 5 is
Stay application. You intended to file a revisional application?
Yes, my lord.
You
My
have
lord,
done-
from that review.
You done so?
Yes, my lord, the revision has been filed.
What is the state of that?
My lord, it has not, my lord, it is running in the list. It has not been called on even for the first
Then
time.
how can you prefer this appeal?
My lord, that is against the order of the dismissal of the review application.
Review application of this order you have preferred?
No. My lord, may I clarify, my lord? My lord, I had filed a review application from the impugned judgment. My lord, where my interest was not granted. Now, my lord, that dismissal of review, my lord, I have preferred a revision application against the order of the dismissal of review. And my lord, against the order of not granting me interest, that is the judgment and decree, my lord, I have preferred the first appeal.
How can you proceed both at the
No,
same time?
my lord, I have filed against the dismissal of the review application. Yes.
Against the review was sought for For recalling which order, tell us.
My lord, the order dated 16th December 2022. My lord, that is at page 18. Oh, my lord, of course, I'm referring to. My lord is looking into the stay application.
Yes.
My lord, that is at page 75.
না তাকে সুটে নয় মানে তাকে সুটে এনকোয়ারির অর্ডার দেওয়া হয়েছিল অর্ডার ইয়ে 20 রুল 12
পেন্ডিং আছে সেটা তো উইথড্র করে নিয়ে আসতে হবে।
যদি রিভিউটা ভালো হয় ডবল ইয়ে করছে।
So today, if the revisional courts allows your review, then what will be the state?
My lord, if the appeal proceeds, my lord, of course, my lord, we have to withdraw the revision, my lord.
That is what we are counting to. That instruction do you have?
Yes, my lord, I have that instruction.
Then first withdraw, then come.
No, my lord,
Withdraw, then
my lord,
come.
my lord, we will immediately mention it tomorrow, and my lord, we will get it
The
withdrawn.
other sides are also there. You have to effect service upon them. Your revisional application has not yet been heard.
No, my lord, it has not been heard.
So you take step mentioned before the court.
My lord, we will do it tomorrow itself. My lord will,
Show us the order.
Then mention.
Then mention before.
or my lord, may I make the alternative suggestion? My lord will kindly,
That will not be proper.
my lord, if your lordship admits the appeal, my lord, we will, my lord, by strength of that order, my lord, we will go and say that the
Your
appeal.
hurry, you want the interest for a belated period. Your
Well,
appeal, it is your appeal. You are
My
not
lord, the
going
money,
for-
of
so
course, my
money,
lord.
you are not interested to get that money also. Now you are hankering on the interest. You have given such a substantive amount, whatever may be.
My lord, I tell your lordship, my lord, the interest portion will be much more.
So right, you are not interested to take that now. So why we cannot wait? You take your step. And I don't know whether at this stage, after fresh instruction, will you take steps for
No, we will,
withdrawing
my
or
lord.
not?
We will, my lord, it's the same advocate on record, my lord. We will do it tomorrow itself.
You do it, come with the order, then we will consider. Yes.
My lord, may I then make one prayer? My lord will keep it on a day on the first week of reopening. My lord, we shall come back within that time. My lord, then otherwise, my lord, my revision application also.
2 weeks after vacation.
Very well.
এটা ওনাকে ফেরত দিয়ে দাও। একে দাও দিকে।
My lord will kindly keep the affidavit of service, my
No,
lord.
no, keep it on that day.
On the
আরেকটা কপি ছিল দাদা।
I give return them আরেকটা affidavit of service.
My lord, item number 18, my lord.
দুটো দিলাম আপনাকে।
Yes, my lord.
আমি
But,
দিচ্ছি।
my lord, this is my application, my lord, but we haven't,
Come at 2 p.m.
Come at 2 p.m.
Don't
my lord, we are
mention
seeking
It
for
is
not
that-
today, my lord. That's
Come at 2 p.m.
okay.
Not.
You are leaving the court.
No, my
Then why you are mentioning? Yes. Yes.
Yes, your lordship. My matter is such, your lordship, that unnecessary after OTS, one-time settlement with the banker, so still they are holding our fixed deposits. So how is it possible? Last time, the single bench order, lordship, order page number 16, I like to read out.
Of memorandum.
Memorandum of appeal, page number 10.
Yes, which page?
Page 10. Lordship, I like to read out.
Last time Lordship has heard them.
Yes.
Single bench, lordship.
Affidavits are complete.
Yes, last time Lordship.
Only thing, my lord, one application is still pending. That is GA number 4.
Which is that?
It is appearing in the list today.
Address amendment. Address amendment.
Address amendment. Last occasion also, your lordship says it is a simple matter. Several times my learned friend raised this question. Address.
Now, what is the present position? You are still retaining the fixed deposit.
My lord, because my lord, there is also injunction in this matter, my lord, for invocation and encashment of the bank guarantee.
has issued a bank guarantee at the instance of the appellant in favor of Bangladesh Rail.
For issuance of such bank guarantee, the fixed deposits were
Yes,
kept as
that is as a
securities.
collateral security for the
Issuance of
bank guarantee.
Very good.
So as far as fund-based accounts are concerned,
Now, what is the difference, fund-based and non-fund-based facility?
the bank which the borrower takes the money from the bank, that is fund-based. And in this, as far as bank guarantee is concerned, they only secured the amount, not they have not taken any money from the bank. They requested the bank to issue
a bank guarantee.
Bank guarantee in favor of the Bangladesh Railway.
Very good.
So bank issued the bank guarantee, and there is it is a
Now
proposal.
that bank guarantee is still continuing.
Yes, my lord.
What was the amount of the bank guarantee?
It now it is because of rate of dollar is changed. It is like 1.5 or 1.6 crore, and they have only they have given security for 1 crore 10 lakhs.
That is the fixed.
That is the fixed deposit. So in case
then what was the dispute? Dispute in the writ petition was they wanted encashment of the security deposit. They wanted
to return back the fixed deposit, which they have deposited, kept with the bank as a security for the bank guarantee. In case of bank guarantee invokes, then bank will
now
appropriate
that position is continuing till date.
Yes, my lord, we are also paying interest every quarter. What is harm in it? They are getting interest at the old rate. Now interest has been come down.
No, what was the prayer in the writ petition?
For return of the bank guarantee.
Where is the writ petition? Has it come here?
Yes, my lord, it is annexed. My lord, kindly come to
page number.
Page 23, I think. No, it starts from prayer starts from
page 23 of what?
Read application, my lord. My lord, that is my lord, kindly take stay application. Stay application, my lord will find from page 74. That is prayer in the writ petition. In these circumstances, your petitioner most humbly pray that your lordship would graciously please to pass following orders. Read in the nature of mandamus, it do issue commanding the respondent bank and its officer and main agent assigned representative act in accordance with law. Read in the nature of mandamus, do issue directing respondent bank and its officer and the representative to forthwith return 9 original fixed deposit as more fully set out in the paragraph 3 above to petitioner. Read in the nature of mandamus, issue directing the respondent bank and its officer when and act in terms of representation dated such and such. Their main prayer is to return back the fixed deposit.
Then what was the compromise petition about?
Compromise, my lord, may I help you, my lord? My lord, kindly come to page 90 of the stay application. Well, this is compromise started. They have issued a letter on 10th.
We come to page 32. What does the court observe?
My lord, kindly.
32 of the stay application. Who is the fourth petitioner?
My lord, court observe. My lord, kindly. The operative portion starts from
page
6. Page 6.
Yes. Place the page 6, the fourth. I have considered.
I have considered the rival contention of the parties and material made available on record. The fourth petitioner was enjoying credit facilities from State Bank of India. The exposure of State Bank of India to the fourth petitioner was both on fund-based as well as non-fund-based credit facilities. The fourth petitioner had approached the State Bank of India with a compromise settlement as contained in writing dated 10th July 2006. That is page 90 in stay application. It had acknowledged that there were two categories of exposure by the bank to the fourth petitioner, namely fund-based and non-fund-based limit. Fund-based limit comprising of parking credit limit and allied current account. Non-fund based limit revolve around the bank guarantee issued by the bank in favor of beneficiary. The compromise of settlement dated July 10, 2006 contains 17 proposals.
This compromise was between whom? SBI and?
Yeah, SBI and appellant.
The petitioner number 4.
Yes, my lord.
This
That is
petitioner
RB.
number 4 is the company.
My lord, RB
And-
Overseas.
And 1, 2, 3 are the directors of the company.
They are guarantors and director also. The compromise settlement dated 10 July 2000 contains 17 proposals. 3 of such proposals which are relevant in the context of the present case being paragraphs 6, 13 and 16 of the letter dated July 10, 2006 are as follows. 6. The bank guarantee would be covered by 100% cash collateral by way of lien on fixed deposit of your bank. Interest on the fixed deposit is to be credited to the current account every quarter. 13. We shall make effort to get Bangladesh matter sorted out and lien marked on the fixed deposit to be released immediately on receipt of the confirmation from the beneficiary of the guarantee or from appropriate authority.
Then what is this clause?
This clause is they have if they settle with the Bangladesh Railway, the Bangladesh Railway make confirmation to the bank that guarantee is no longer is required by the Bangladesh.
That bank guarantee is no longer required.
No. If Bangladesh Railway, this clause means Bangladesh matter sorted out and lien marked on fixed deposit to be released immediately on receipt of confirmation from the beneficiary of the guarantee.
So now the next clause is on payment of 85
On
lakhs
payment
and-
of 85 lakhs and creation of 100% cash cover for the outstanding bank guarantee. As proposed, the bank shall issue no dues certificate.
That was issued.
That was issued. As far as the loan account concern of the this appellants, kindly see that is annex in page.
Let us first understand what is the matter.
Kindly come to page 97. The no dues certificate issued by the bank.
Bank is continue to remain outstanding till date. तो क्या ना बोलते? Page 11. Bank guarantee continues to remain outstanding till date. Bank guarantee outstanding কেন হবে? Security কে রেখে দিতে পারবে।
ব্যাংক গ্যারান্টি দিয়েছে বাংলাদেশ সচেতন বাংলাদেশ আবার একটা কি ইয়ে করেছে
Mr. Srivastava, kindly come to please page internal page 11 of the impugned order.
My lord.
Kindly come to the middle of the paragraph. 27 September 2006. Have you seen that?
My lord,
The bank guarantees continue to remain outstanding till date.
My
What do you mean to say by that?
my lord, bank guarantee is still,
Suppose I had a 100 rupees fixed deposit in SBI.
my lord,
For that 100 rupees fixed deposit, keeping that as security, you have issued a bank guarantee to the tune of, say, rupees 100.
my lord.
Now, there was a compromise between you. The question was, one was non-fund based facility, other was fund based facility.
My lord.
We are concerned with the non-fund based facility
My lord.
because that is pertaining to the bank guarantee.
My lord.
Now, you please explain to us what is this non-fund raised facilities for which you are withholding the fixed
My
deposit
lord,
certificate.
then my lord, kindly,
Please complete that. The bank guarantees continue to remain outstanding till date, although nothing is placed on record to suggest that the beneficiaries of such bank guarantees,
my lord,
that is their Bangladesh counterpart,
my lord.
had lodged any claim with the bank.
বরঞ্চ তারা ইয়ে দিয়েছে ওই কি বলেছে নট নেসেসারি
So they have not sorted out the problem with the Bangladesh?
Not yet, my lord, because award has been passed against them. And in the award, my lord, I have annexed.
Award has been delivered in between the petitioner appellants and the Bangladesh counterpart.
Bangladesh.
So what has been said in that?
My lord, in the said award, unless they satisfy the award amount, if they satisfy the award
Bangladesh
party Bangladesh Railway, then Bangladesh Railway issue no objection certificate for release of the bank guarantee. My lord, that is award annexed in my opposition. My lord, kindly takes my opposition once.
Now, this award was delivered in connection with which proceedings between them?
Between the contract between them.
There was a contract.
Laying tracks in Bangladesh.
So what was the award outstanding amount?
My lord, kindly come to my affidavit in opposition as.
But that has not been referred to in the order impugned in the writ.
My lord, they have suppressed the award. They have suppressed the award and filed the writ application before this honorable court for release of the fixed deposit.
So your
that is award amount is mentioned.
Many petitioners had made efforts to sort out the Bangladesh matter
and got them
get the lien marked in the fixed deposit
release in terms of
the compromise. একটা পয়েন্ট লিখেছে যে ব্যাংকের উপর লিয়েন থাকতে পারে, সেটা ওয়াজ এগেইনস্ট ডিসাইডেড এগেইনস্ট। এখন যেহেতু দিস কম্প্রোমাইজ পিটিশন এই ক্লজ 16 এ ছিল যে this will be subject to a no objection by the Bangladesh part, 16 clause-টা এই যে on payment of 85 lakhs and creation of 100% cash over for the outstanding bank guarantees as proposed, the bank shall issue. Page 7.
No due certificate issue করেছে বলছে তুমি।
হ্যাঁ, নোটা ইস্যু করেছে সাবজেক্ট টু দি কন্ডিশন। কোন পেজে? Last portion, the writ petition does not demonstrate.
From the beneficiary.
Compromise settlement cannot be made and construed in isolation. It has to be
receipt of the compromise.
No, internal page 13 of last page of the judgment.
My lord.
In the facts of the last para, in the facts of the, therefore, issues with regard to bank guarantees remaining as inter alia, the suits are still pending. Suits are in connection with what?
Connection with the bank guarantee for invocation and encashment of the against the invocation and encashment of bank guarantee. We are suffering injunction. We the beneficiary cannot invoke.
Suit was filed by whom? The
By
petitioner.
appellant. Appellants.
Claiming declaration for what?
That,
Where is the suit? Where is the plaint?
It is their suit. I don't know.
No, that suit was between whom?
Between
The petitioners and the
appellant, bank and Bangladesh.
Now, in this proceeding, the Bangladesh counterpart is also implemented here. In this writ
No,
petition,
no,
they are
no,
not
no,
there.
no.
Now, then what was the award in connection with the bank and the petitioners?
My lord,
That was due to the contract between the bank, between the Bangladesh counterpart and the petitioner.
my lord.
So that is one part of it.
My lord.
And then award was delivered when?
In the year 2005, I think.
And when was the suit filed?
Suit is earlier.
So unless you people come with a list of dates, how can
My
we
lord,
understand?
certainly, my lord, because my lord, I will not expected that appeal is.
What is the position in the suit now?
They
You are a party in that suit.
My lord, we have not appeared in as yet in the suit.
The suit was of which year? Do you have the plaint?
Yes.
Do you have the plaint?
That plaint I don't have at this moment. That is because your lordship, it is on the Hon'ble
Unless
court.
you bring the plaint from the
Whether suit is still pending.
Still pending. Matter, I like to.
What is the stage? At what stage?
Show us the plaint. Will show us, tell us later. First, show us the plaint.
So this matter, I can.
You may be knowing the facts.
All.
To see the facts. We want to see the plaint.
Bangladesh, the suit that should be.
Bank is a party there.
Yes, your lordship.
Show us the plaint and show us the present. What orders have been passed in that suit?
Your lordship. Your lordship, my humble submission is that the director and petitioner is present here. He knows all ins and outs. If any point, your lordship, arises in between, he is standing here.
He has engaged you.
Right. He knows.
We are wanting to know the present status of the suit and what in that, whether they entered appearance and filed written statement. What is the position in the suit?
That is pending still here.
In that you have sought for invocation of the bank guarantee stay, so that they cannot invoke the bank guarantee.
On that part, my some point is there, your lordship, that why it is pending. So far, knowledge goes. I give my information that the parties, they never appeared since 23 years. Not only here, in Bangladesh, Supreme Court also issued rule nisi against them for our payment in Bangladesh. The Bangladesh government
against who?
Rule issue. This is here. Against Bangladesh railway government, but they never appeared since 23 years. Like that, he had two suits were filed because the State Bank.
We want to know these suits. Where have you stated in your petition about the filing of suits?
Petition to
they have suppressed this material.
No, suppressed. He
They-
is suppressing.
they have
because
not stated anywhere in
fraudulently, your lordship, fraudulently, State Bank with the contribution of Bangladesh government, they in case our.
We are to hear your submission without seeing the records. We are asking you one question. Where are the plaintiff of those two suits? We must understand what is your problem. Where are the plaintiff of those two suits and what is the present status of these suits? What orders have been passed in that?
No order passed, that's because nobody appeared or defended.
So is it still subsisting?
Subsisting.
To show us that.
Because these are
This way we cannot take. Do you have two plaintiff copies? Do you have the plaintiff copies?
no, and we don't have at this moment as because I know that everything is here, your lordship.
It is not here, sir.
On that line, I have 2-3 points I like to, your lordship, please. My point is that like that. Since 23 years, no benefit.
We have asked you a question. We want you to show us the plane. If you do not prepare yourself, how will you argue before us? Have you seen the plaint? Have you read the plaint?
No.
So then
Your lordship.
how can you answer our? Don't hand over papers like this. There are two suits pending in which bank is Mr. Srivastava. Also, you are a responsible person. Is it not your duty to tell us that these are the position of the suits? We are unnecessarily dealing with the matters for repeated.
I'm sorry, Milord, but bank has not entered appearance in that suit.
You must have been served the summons.
Only we have served the status quo passed by this honorable court. That
You
order
are
I
our
will.
officer. You must let us know that what is there in the bank's pocket.
Then my lord, kindly give me some time so I can bring those.
Why didn't you bring that fact on record in the affidavit in opposition to the stay application? Have you stated anywhere in the opposition?
My lord.
You have stated. Show us. Yes, file two suits, CS 273 of 2022 and CS 464. Respondent is a defendant. Honorable court passed interim orders in both the suits.
My lord.
So you have been restrained from invoking the bank guarantees.
It is status quo.
Status quo.
As regards invocation and enforcement of guarantee.
When was the status quo order passed, Mr. Srivastava? Please help us.
My lord, itself in the 2002, long back 2002.
এই সুদ থাকা সত্ত্বেও এরা কি করে রিট করছে?
সেটাই তো বুঝতে পারছি।
My lord, in this matter, they themselves created a lien in favor of the bank. They themselves proposed lien in favor of the bank.
Let us understand. 2002, there was the suit.
My lord.
Seeking restraint order upon you not to invoke the bank guarantee.
My lord.
That interim order is still continuing.
My lord.
In the meantime, they came up with a settlement with you in the year 2006.
My lord.
In the settlement, they said that the Bangladesh party, we will settle amongst them and we'll let you know so that you can issue the no objection certificate.
My lord.
A condition was incorporated which you showed clause 16 of the compromise petition.
My lord.
Now you are explaining that clause by saying that this is subject to settlement with the Bangladesh Railways and the petitioners. That dispute has not yet been resolved.
Correct, my
such we are not in a position to say that we have given no objection as regards return of the fixed deposit.
My lord.
So we want to know from you. On one hand, they have approached the suit court and obtained an injunction from invoking the bank guarantee.
My lord.
And on the other hand, how they can file the writ petition saying, return me those fixed deposits.
That is my main opposition.
So that is why your main opposition, where is that fact in the order of the court? Order of the court does not say so.
No, my lord, kindly come to order.
বেঁচে আছে না মরে গেছে কি করে জানবো?
My lord, kindly come.
Order shall be communicated who would be at liberty to file the vacating interim order upon notice. লিবার্টি দিয়ে দিল ভেকেট করার জন্য, তারপরে কিছু বলেছে এটা 24 এটা আরেকটা সুপার না এটাতেও তো সুপার এইটাতে এইটা কত সুদ না
নাম আলাদা
না আরবি ওভারসিজ প্রাইভেট
দুটো এক আরবি ওভারসির মালিক টালিক হবে
আরবি ওভারসিজের ডিরেক্টর
ডিরেক্টর
ভাটিয়া রামকুমার রতনলাল শ্রুতি ভাটিয়া
হ্যাঁ
হ্যাঁ ফেরত দিল
I will kindly come to page 4 of the impugn order. I will kindly come to page 4 of impugn order. Last but 10 lines. Submit that no due certificate issued by letter dated July 29 should also be considered in such case. He contends that the petitioner are guilty of suppression of material facts. The petitioner did not state. There are two suits pending filed at behest of the petitioner relating to bank guarantee involved in the non-fund based credit facilities. He draws attention of the court to the averment made in the affidavit in opposition and also affidavit in this regard. He submit that as on date suits are pending after being restored at the behest of the petitioner. He submits there were subsisting interim orders in the suit. Therefore, it cannot be said that dispute with regard to the non-fund based credit facilities stands sorted out for the bank to release 9 several fixed deposit or any one of them in favor of petitioner. These are the submission made by me before the trial particular.
So you let us know whether bank is still, that suit was of 2002, interim order was 2002.
My lord.
So you have
Well,
not
that is only in respect of invocation and encashment of bank guarantee. But as far as the agreement between the
there are two parts pertaining to the fixed deposits which they want back.
No, not fixed deposit. Bank guarantee.
The writ petition.
Writ petition is pertaining to the fixed.
So he wants to get back those fixed deposits.
My lord.
Which according to you have two portions. One is fund-based facility and another is non-fund-based facility.
No, Millard, may I explain, Millard? Millard, there are the loan account of the appellants with the bank. As far as loan account is concerned, we have settled it. Settled the matter. But they have paid 85 lakhs and odd. We have released all collateral security, all immovable collateral security in favor of them. Millard, but as far as the bank guarantee is concerned, they themselves propose that we are giving cash security for issuing a bank guarantee. That is the
fixed deposit.
That is the fixed deposit. So there are two things, Millard. As far as fund base is concerned, that is matter is settled.
Settled.
And as far as bank guarantee is concerned, they have given these fixed deposits as a security for bank guarantee. In case of Bangladesh invoke the bank guarantee, then bank will appropriate those fixed deposits. Now they come up with the writ application to asking the order from the Honorable Court to return back those fixed deposits. Suppose, my lord, in future, in case of Bangladesh Railway invoke the bank guarantee against me, then I have obliged to pay them, because it should be as far as bank guarantee is concerned, bank is bound to pay the amount to the beneficiary. My lord knows that. My lord, in that case, bank will suffer. That is why the cash security is still holding by us, and we are also giving interest.
Kindly come to page 7 of the order.
My lord.
Is clause 13. Please read clause 13. We shall make efforts to get the Bangladesh matter sorted out.
Sorted out, the lien
This thing can never be sorted out because there is already an award against them. That award between Bangladesh Railways and
then,
the petitioners.
my lord, that is why, my lord, I'm just requesting, my lords, to come to my affidavit in opposition. That I have annexed the award. My lord, kindly come to pay.
No, Mr. Srivastav, what is the meaning of this? That we shall make efforts to get the matter, Bangladesh matter sorted out. What is the Bangladesh matter?
The contract between they have violated the contract. Bangladesh Railway files a claim in the arbitration proceedings. Then awards has been passed in favor of Bangladesh Railway against them. My lord, award is more than $325,000 US dollar. $325,000 US dollar.
Have they taken any action against that award?
Then the
award is of which year?
2005. My lord, it is passed 2nd July 2005.
2nd July 2005.
My lord,
yes, Mr. Mukherjee,
I
what
was
happened?
satisfied. Your Lordship, in this matter, I like to elaborate because the two suits are pending as because fraudulently with the State Bank of Dhaka branch and the Bangladesh Railway government, they fraudulently encase our security. That's why the two suits here, according to your Lordship's direction, we have sent them all the papers for their appearance here. Since 18 years, nobody come up here, and at the same time, we have filed Bangladesh Supreme Court that they are not paying our money. So
who is not paying your money?
And that is Bangladesh Railway.
So Bangladesh Railway has already obtained an award against you of more than $3 lakhs.
Your Lordship, this is that's the point mine. They are very influential. That's why not to payment our agreed amount because
Mr. Mukherjee, there is an award of 2005.
So that's the point I raised.
Satisfied the award amount?
No. We have objected it. We have
objected. The award is against you.
It's the private body. That's the point, Your Lordship. I am telling you, Your Lordship, that is the point. Please, Lordship, 1 minute.
You have filed any application in respect of the award, either seeking set aside or appeal.
On that particular point, I like to say 2 minutes, Your Lordship.
You just give us the information.
No,
so that we can come to know what has happened.
No, that's the objection we have filed there. That is the private body with the Bangladesh government. They not giving
objection against before whom? Arbiter passed the award. Then where you have filed objection?
So firstly,
arbitration access, either you have to file an application for setting aside the abatement or you have to file appeal.
Yes, Your Lordship.
Which path we have chosen? Tell us.
That's the main issue, Your Lordship. Please, why they are going that part? Because they fraudulently, they encash, Your Lordship, encash our money. They are very powerful. Your Lordship, as because actually
you have to bring no objection, no dues from your Bangladesh counterpart.
Your Lordship.
Well, that is mentioned in the award itself.
Yes. You bring it and take back your fixed deposit.
Your Lordship, we have done a lot of things since 23 years. That's because that's why we have been to the Hon'ble Supreme Court in Bangladesh. They issued the rule Nishi for the payment of our contract amount, but they have not paid. They're such a powerful as because without bill of lading.
Who is this overseas This company, who is this company? Your director is here.
No, I'm not director here.
Your director
Ye-
is
Yes,
here.
yes, yeah.
Yes, come in front.
Yes, your
Why don't you explain the entire episode to your advocate? We are not being able to understand.
I am so sorry, sir. I did explain them quite a number of times. Then I said, let me be here in case if you allow me to speak for 2 minutes, sir.
So tell us about the award amount.
So this award amount, basically, sir, there was 2 contracts that was issued by the Bangladesh government against ADB funded loan. We shipped the material duly inspected by the Bangladesh government authorized representative. There is a clean bill of lading, a clean maid's receipt.
We are not on that. There is an award against you.
Sir, our contract amount was not paid, and instead of
Right, you are aggrieved by that award.
Yes,
you ought to be aggrieved by that.
Yes,
Have you taken any steps?
yes, sir. We already objected. There is an objection that we have filed with the ICC that we are not agreeable.
But has it been disposed of?
No, sir,
Your
that-
objection has been dealt
No,
with.
sir, it has not been disposed of. It is still pending in the Bangladesh.
So till date, you are having a due to your Bangladesh counterpart. No further order has
Not
been passed.
sorted out.
It has not been sorted out.
No, sir.
So when it has not been sorted out, we are wanting to understand you entered into a compromise with the bank
Yes, sir.
that we will pay 85 lakhs. That portion is clear. They have given you no due certificate. So far as the other clause where you said that we will negotiate with our Bangladesh counterpart and come back to you so that you can return those fixed deposits to us. Now, admittedly today, this dispute between you and your Bangladesh counterpart has not yet been resolved.
Sir, it will, your lordship, just for 2 minutes, sir, this can never be resolved because, sir, the whole basis premise is that the contract payment, a CA vendor contract was not paid.
Then how can we help you? If
Sir,
if you entered into a compromise petition with them, that we will settle it with our Bangladesh counterpart and come back to you.
Your lordship, there's a small thing in between, sir. Sir, the guarantees that is we are talking about, sir, the settlement with the Bangladesh is one part about the contract amount. And what we are settling with Bangladesh, so these guarantees have lapsed on the date of settlement, on the date of OTS. The bank has never extended these guarantees. The guarantees have lapsed due to the efflux of time.
So that is a development after you obtained the injunction in the pending suit.
So that was in 2002.
So we do not know all these things unless you apprise us in a tabular fashion or in any manner by you please sit with your counsel, explain to him that these are the plaints, give him copies.
Yes, Lord.
Unless you give the plaint copy and the present status of the suit, we won't be able to understand this.
Your lordship, tomorrow itself, if you allow me, I can just come back, sir, with all the.
You find out the documents, information. We are unable to understand 2 things. Keeping these 2 suits pending, how we can approach the writ court. And if your problem with your Bangladesh counterpart is not certain, how direction for release of your fixed deposit document or fixed deposit amount can be given.
Your lordship,
You kindly apprise us these 2 things.
Sure, lordship, I'll come back with this. Your lordship, there's one more point in this.
No other point. First, satisfy our query.
Okay.
You have understood what
Yes,
my
yes, I
brother
have
has-
understood.
So you keep that thing in your mind and explain to your counsel so that we can get those, we can be apprised of these 2 issues. You have to supply him all the plaint copies and whatever pleadings which have been exchanged between the parties and what is the present state.
Sure.
Otherwise, it is impossible to adjudicate.
Mhm.
And Mr. Srivastav, you are first award officer, then a counsel for SBI. Is it not your duty to assist us?
As far as
Please make a chronological date of events.
Madam.
You have said one thing, they have suppressed this fact, etc., etc.
Madam.
You made a chronological list that what is the problem, whether negotiation to what is your point? Because clause 16 said that they have to sort it out with the Bangladesh.
they themselves written to us.
Also assist us with all the documents you have. 2002 suit plaint, you said we are not having any documents. You are party to that suit.
But we have not entered appearance in this suit as yet. We got only order which I can bring before your lordship.
Your lordship, if you permit me to
This way, Mr. Mukherjee.
Now,
please,
these two, I like
we are
to
trying to.
hand over.
What is that?
There is the details in this case in all respect. So you just, I hand over, Your Lordship.
Do you have the copy of the plaint there?
No, no.
You have heard what we have said.
Yes.
Please sit with your client, obtain the answers and give it back to us. Mr. In course of hearing, please for an accommodation to avail further instructions. In view thereof, the matter stands adjourned. Stop. Listen to matter for further consideration. আছে আমাদের সাহেবের সাথে আর কোনো বেঞ্চ 15 তে কোনো বেঞ্চ নেই তো আমাদের একে ডাকো আমার অ্যাপেলেট সাইডের অফিসে তো কোথায় যে কোনো দায়িত্ব তোমার
बैंक
15th June 15th June 2 तारीख একটা সময় Yes, come on
15th June. But in the meantime, Your Lordship, one-time settlement matter, what the amount we have deposited. So what will be the effect that I asking my learned friend, what is one-time settlement when all the dues
that
were
has
paid?
been explained in the order which has been impugned in the appeal. Why did the court did not take into consideration your argument has been expressed in the order itself. First, you have suppressed.
No.
Second, you said that we have not yet arrived any settlement with Bangladesh authorities. In view of those three factors, the court said that I will not interfere because there are pending suits. You have gone through the order. You satisfy sitting with your client, obtain the necessary records, make a compilation and bring it to us so that we can dispose of the matter.
Yes, Your Lordship, but one point is that since 23 years, they never appeared nowhere in Bangladesh, your noble code. So what is the problem? That's the problem of ours. We can't bring them. Since 23 years, we are facing this
We
problem.
are not concerned with them. We want to see the document that your dispute with Bangladesh Railway stands resolved. Show us that document, finished. You don't have to do anything.
Then Bangladesh, Your Lordship, Bangladesh Supreme Court, why they issued? No, why they issued? As because they are asking them they to
Are
pay.
you questioning this court?
No,
Then
Your Lordship, no.
are you questioning us?
No, Lordship. I tender my apology.
What we are saying?
I tender my apology.
Problem and you bring us the records. Then only we can decide.
I tender my apology.
Mr. Srivas, please help us with the details.
Certainly.
So that you can also sit with your, whatever queries they have, whether anything, because once there was a compromise. If there can be, the matter can be sorted out in any fashion, then we will direct that this gentleman to go to your office, sit with your persons. If any sort of solution can come up. You are our officer.
Your Lordship rightly asked them to produce the document, whether they have settled with the Bangladesh Railway or not. My Lord, kindly consider this as well. State Bank of India has business all over the world. if suppose as far as bank guarantee to the Bangladesh Railway is
Mr.
concerned.
Srivastava, we are not on that. You are seeing that he is not being able to place all the documents before us. You can call your officers and you can appreciate as to whether in any manner the dispute can be resolved. Good, bad, indifferent, you are also paying interest for more than 2 decades and they are also not getting better. So
we are paying
bank
higher
is suffering.
interest because earlier there was.
Bank is giving interest upon the fixed deposit. As you said, you are suffering. So why don't you call your officers and you have an initial discussion with them? If you get some sort of solution, come and tell us so that we can also tell him to go to your office and find out any sort of method where.
Certainly, certainly.
The 23 years, no, nothing has happened. So we request you to that effect, you take that instruction. If required, you call Mr. Mukherjee. His client will come over and you can discuss with them as regards the issue and come back to us that for this reason it cannot be solved or this can be solved if this is done. Finished.
Lordship, Reserve Bank also insisting us. So why foreign exchequer not coming since long? That's the problem. We are appeared there also.
Okay, we have understood. On 15th.
I'm grateful to
Oh, just a moment. It will be on 20th, 20.
20.
Tuesday. Okay, very good. Yes. Please see me, Srivastava. Come with this instruction.
আঠেরো থেকে হবে টাকা 2,25,000 হ্যাঁ তো কথা বলে
State Bank Indians and interest to payment. আমরা শুনবো না আমাদের একজন
My lord, I'm for the respondent, my lord. My lord, it's my application for correction of the judgment, my lord. 1819, my lord.
Oh, that matter.
1890.
Mr. Chakraborty,
Yes, my lord.
Where is Mr. Maiti?
Where is
My
Mr.
lord,
Maiti?
I tried to serve him, my lord, on Thursday and Friday, but he is not there. Yesterday he come, but he refused to take the. So, my lord, I served him yesterday by the way of speed post, and he received it today, my lord.
Who received it today?
Mr. Maiti.
You send it to Mr. Maiti or his client?
I also send it to his client
Where is
on
your
Thursday.
affidavit of service?
My lord, I will make it here tomorrow, my lord.
Yesterday, on several occasions, we sought to serve personally, but Mr. Maiti did not receive. That's why yesterday we have posted track report. We have not yet received as yet. So
In the track report and
yes, yes, my lord.
give us the affidavit of service. We
Yes, my
pass
lord.
the necessary.
Yes, my lord, let it be kept tomorrow, my lord.
Day after tomorrow.
All right, day after tomorrow.
I'm grateful.
Service
Without the affidavit of service, we will not pass.
no, I shall file.
শোনো, ওই বইটা দুটো কোথায়? ওয়েস্ট বেঙ্গল সিনিয়র সিটিজেন প্রোটেকশন আগের দিন বলে দিয়েছিলাম। ইম্পর্টেন্ট ম্যাটার যেটা ডাকতে যাচ্ছ সেটা লাগবে। বইটা শুনছো?
Maintenance of senior, ওইটা
এই করে করে আমাদের তোমাদের জন্য না,
এই যে এখানে একটা
পেশেন্ট একটা দেখছিলাম। ও কোন দিন আর যাচ্ছে না, আমাকেই তো দেখতে হচ্ছে।
My lord, I am for the respondent number 4 and 5, my lord. The parents.
It's your other side.
Other side several times is not coming and taking time, my lord, only to harass the parents, my lord. Not to give the as per the honorable justice order, not even the maintain in the area of maintenance.
Yes, place the case.
My lord, what happened? The parents, that is the respondent of this application, filed one petition before the subdivisional Kharagpur for maintenance of the Maintenance and Welfare of Parents and Citizens Act 19. So
where is that application? First place the ordered impute. First place the order which has been challenged. Then you can come to the facts. Let us know what is the order. 10th of August 2018.
yes.
Place the order. Any earlier order was passed?
Yes, my lord, justice. Earlier order, my lord. This court already passed earlier order also.
Not this court.
I am coming. Read court, my lord. I am coming the order of Honorable Justice, my lord, Dibanshu Bosa, my lord, the appeal, page 97 and 98, my last page
Of the stay applications.
of the appeal, my lord. That is the CAN application 7721 of 2018 and MAT number 1147 of 2018. That is the appeal.
Page
Page 97 and my lord 98.
97 is 10th of August order.
No, my lord, here is the copy of this appeal, my lord.
Stay application.
Hmm.
Which page you are saying?
97 and 98, my lord.
That is the order challenged in the appeal. Prior to that, any other order was passed.
The other was passed by that is the SDO of the Kharagpur. That is the appellate. Only they have come against that order challenge before this writ court.
Where is the order of 5th April 2011? Writ court order of 5th April 2011, which was vacated by the order.
Not here annex, my lord. That 5th of the order, the appellant, my lord.
Now, how much he is paying to you now? How much he is paying to you now?
My lord, the order has been passed. The justice was asked that is 6,000 per month, and even the learned appellate tribunal. And thereafter, he paid 6,000 rupees per month. Therefore, they have stopped that order. After that, when I filed this year to complain, then he is starting the rupees 2,000 area. So that he is paying 6,000 plus 2,000 areas till now.
Yes.
But during after paying your lordship's order, that is,
So they have accepted to pay 6,000 to you per month.
per month.
And whatever is the area due, they are saying that we will adjust it by paying 2,000.
2,000 per month.
So how much has been adjusted and how much is remaining?
Yes, my lord, I am. My lord,
We are wanting to see the 5th April 2011 order. Because of this reason, there the court directed payment of a particular amount.
particular amount rupees 6,000.
You have that order with you?
No, my lord. Only Justice Bosak order is mine with me.
এদিকে আসো। ওই গল্পটা কম করে দিয়ে observation টা। ওকে ডাকো, কম্পিউটারে কে আছে? এটা লিখুন তো WP 4770 W of 2011. এটার একটা অর্ডার হয়েছে দেখুন 5th April 2011. তা পান কিনা এখানে পেলে একটা প্রিন্ট আউট বের করুন। WP 4770 W of 2011. 5th April 2011.
অর্ডারটা কই এই অর্ডারটা দেবাংশী বসাকের কাছে 5th April অর্ডারটা কই দেখ মরান
So now the dispute is only as regards the areas
Arrears along with current payment, that is 6,000 per month.
that they are paying to you, that he is paying to you.
Not giving regularly.
The order to see doesn't have a job. This order of 13 July 2011 was passed without July.
আরে অর্ডারটা বই তো থাকে এই হচ্ছে 35 এগুলো মানে কেন এটা 6,000 টাকা হলো কি হলো কোনো একদম মানে
And that too without signing a whole copy.
SGODM কে বিচারক করবে বলে উঠে পড়ে লেগেছে সেক্রেটারি
এবার এইটাতে পেজ 51 ঠিক আছে and notice
অর্ডারটা নেই তো দেবাংশী বসাক অর্ডার বাড়বো ইয়ে করা যেতে পারে এটা যে উইদাউট দ্য প্রিন্সিপাল অফ ন্যাচারাল জাস্টিস হ্যাঁ সেটা সাইড করে যায় executive has been given power সেটা চাইছে স্যার next got any order
তার দরখাস্তের জানাতে আমাকে প্রদান করা তার জন্য একটি দরখাস্ত দাখিল করেছি দেয়নি তুমি ওটা রিকল কিছুই রিকল করবো না 9-2 বেসিসে টাকা
হিয়ারিং আপন স্যাটিসফ্যাকশন কতটা ব্যবহার করছে আপন স্যাটিসফ্যাকশন কি অন বিং স্যাটিসফাইড এটা কিভাবে স্যাটিসফ্যাকশনটা রিচ করবে
5th April ডেটটা বললাম তো 5th April 2011 disposed of ওইটা তার আগের অর্ডারটা চাইছি সেটা তো ফাইনাল অর্ডার পাস হয়েছে
এই অর্ডারটা এই অর্ডার
এই 92 না ভুল আছে একটা
আরে ওই রিপিটিশন ওই কম্পোজিশন চাইবো না সেটা হলো হ্যাঁ এটা কম্পোজিশন এই যে 9 এইখান তো অন বিং স্যাটিসফাইড অন বিং স্যাটিসফাইড মানে এটা তো সেই এক্সপার্টির মতো করে দিয়েছে এবার অন বিং স্যাটিসফাইড এই স্যাটিসফ্যাকশনে পৌঁছাবে তার মানে হ্যাঁ এইটা হচ্ছে যে ও অন দ্য বেসিস অফ দ্য মেটেরিয়াল টেস্ট বিফোর ইট হি অ্যারাইভড এট এ কনক্লুশন দ্যাট দেয়ার ওয়াজ এ নেগলিজেন্সি অ্যান্ড রিফিউজাল
আর কোড বলে দিল যে প্যারা টিচার so from 10th of August 2018 your dues were if we take this date into consideration they started payment to you at 6,000 rupees
Yes.
now he's continuing to pay 6,000 the dues which were there
Yes,
which
my
was
lord.
being adjusted as 2,000 per month he has paid you 25% of the dues on one day remaining 25% on another day now he's continuing to pay 6,000 he has a child and a wife you are two aged persons now why you are 6,000 he is paying so what more do you want
My lord, as per Act and rules, that is under section 9, the maximum payment is rupees 10,000, so that total amount, whatever may be dues or whatever may be, but my client, that is respondent 4 and 5, wanted rupees, that is maximum amount rupees 10,000. There is no claim at all. That is the main, including area and what.
Wanted 10 you may have wanted 25,000
Yes,
your
no.
prayer was allowed to the extent of 6,000
Yes, my lord.
that order you have not challenged
No.
so you are satisfied with 6,000
Yes, my lord.
he is paying you 6,000
Yes, my lord.
what more do you want sir
My lord, during the pendency of this order, he is paying rupees regularly 6,000. But on the occasion, they have stopped the payment.
go and deal it with the subdivisional magistrate go and satisfy him
Yes, my lord.
my lord salary has whatever is due whatever you want
স্যালারিটা কেটে নিতে বলেছে ডাইরেক্টলি হ্যাঁ
রাতের সাথে বসে শুনছি দেখো
ব্যাংকটা 75,000 ইস্যু 25,000 এটা হার্ডিন পার্ট আছে হ্যাঁ ইনস্টলমেন্টে দিয়েছে এই যে এইটা অর্ডার দিয়েছে অ্যাপেলের ট্রাইব্যুনাল নিয়ে গিয়েছিলেন the principal such and such will deduct amount directly from his salary and pay to interest. এই অর্ডার অনুযায়ী
no further increase of maintenance as claimed is accepted now. You prefer appeal also?
No, I will not prefer appeal, but one thing, my lord, my submission,
Only you
that-
can prefer appeal.
my lord,
Son will not be able to prefer appeal.
my lord, son is preferred the appeal. I am not. My lord, kindly let me allow. One thing is that I filed the maintenance, that is appeal before the sub-divisional court as according to rules. But here they have challenged the writ court. Now, writ court, the order has been passed, that is stand on the order of learned tribunal. Now, what happened during the courts of the writ court, they have filed this appeal before the honorable court. So, what happened? They wanted to not to give the first rupees 6,000, number one. Number two, at the time when the tribunal was passed, at that time his salary was rupees 11,000 or 12,000 like that. But now he is drawing rupees more than 45,000.
That will be decided in the application. That will be decided in the application which is pending before SDO. Your proceeding before SDO has not been finally disposed of. He has come against an interim order. Court said, court initially granted an interim order. Then there was a misstatement that he is not an employed person, etc. Court vacated the interim order. He was not paying that amount to you. You preferred a statutory appeal against that order.
Yes.
Before the DM. DM said 6,000 plus 2,000 towards 8 years. Finished.
এবং ইনক্রিজটা রিফিউজ করেছে ডিএম। পেয়ার ফর ইনক্রিজ রিফিউজ করেছে।
Appeal তো merit আছে।
অ্যাপিলে মেরিট আছে। আফটার ভ্যাকেশন কিন্তু বাবা মা কি করে?
But every ক্ষেত্রে আমার কোনো ইনকাম নেই।
সেটা ওই আদার কাছ থেকে ইয়ে করেছিল। হ্যাঁ।
ওকে তো আমরা রিলিফ দিতে চাইছিল রাজনীতি করে। চিফ জাস্টিসের কাছে
একটা সুযোগ দেওয়া যায় নাকি ছেলেটাকে?
Then what is your due according to you?
My lord, my dues is total dues, my lord, 3,90,000.
As per our order, they have once paid you 75,000.
75,000, yes, my lord.
50,000.
Yes, my lord.
Then 1,25,000 has been paid.
Thereafter, he is not paying.
Thereafter, he is going on paying 6,000 to you plus 2,000 towards area.
Only 3 months, my lord.
Very good.
He is paying till March.
Make up your mind who will speak.
My lord, let me allow to give me a statement of the accounts, what I have received and what they have given me.
Why this person? He was there on the earlier occasion.
After vacation.
No one appears on behalf of the appellant, though Mr. Chakraborty, learned, Pakrashi, Mr. Pakrashi, learned. Pakrashi, learned advocate appearing for the respondent numbers 4 and 5 is present. Appears on behalf of the appellant and no accommodation is sought for.
Ahora dije চুপ করো। 25,000 বার করো, 25,000 because you.
As a last chance, the matter stands adjourned. Matter for further consideration in the daily supplementary list of this court. On 20th. Stop. We have kept it on 20th, give a notice to your other side along with a copy of this order.
20th June.
No one appears on their part, we dismiss the appeal.
My lord, 20th June.
Your lordship, I beg to appear for the respondent wife, your lordship. Your lordship, I have given several notices, your lordship, but the addressee has not been found, your lordship. It has come at my instance, your lordship.
Matrimonial appeal.
Yes, your lordship.
It's a matrimonial appeal.
Yes, your lordship. Your lordship.
21. What you are saying? 21 is a man now.
Residuary matter.
21.
What you are saying? This is a police inaction matter. Ranjit Kumar Mondol. Matter number ta kot? At 1217 ta ki?
Lordship, it is my matter only, lordship. Now FMA has been instructed, lordship. I appear for the respondent wife, your lordship. The applicant is not here, lordship.
What is the name of your client?
Your lordship, my client's name is, your lordship, Onita Mondal, your lordship.
Problem has that.
Okay, lordship.
Ranjit Kumar Mondol versus State of West Bengal is a police inaction matter. What was the number of your writ? It was any writ petition you filed?
Yes, I have not filed, your lordship. The appellant have filed, your lordship. Had filed. The writ petition is, your lordship.
It's a private representative claims that a sum in itself.
Your lordship, WP 12535W of 2019, your lordship. The order was passed by Honorable Justice Devanshu Bosak, your lordship.
You are for the respondent.
Respondent wife, your lordship.
Why did the husband, the petitioner was your husband?
Yes, your lordship.
Why did he file the writ petition?
Your lordship, because of the order passed by the learned trial judge, your lordship, that I have to my husband have to pay, your lordship, the area dues, your lordship, and the monthly remuneration, lordship. But till date he has not paid a single penny, your lordship. And the execution case I have filed before the learned trial court, that is pending, your lordship, since 2019, your lordship.
Dismissed.
Dismissed by Honorable Justice Devanshu Bosak, your lordship.
Order of maintenance was passed in 125 proceedings.
Yes, your lordship.
Oh, the payment is not being made, and hence you have come directly to the writ court.
Yes, I have not come, your lordship.
Oh.
He had preferred an.
What was the complaint lodged by him 7th May 2016?
Your lordship. Actually, your lordship, this is a transfer brief, your lordship. So I have to take instruction, but your lordship is pertinent to mention over here that
Not
Now, what is the stage of the maintenance proceeding then?
Your lordship, it is pending, your lordship.
Go and take steps there. Let warrant of arrest be issued.
Your lordship, but
There is no stay up by the lead court. Then why you are not taking steps?
your lordship, the appellant has been fled away, your lordship. I'm not getting any type of address. I've sent through mail, your lordship. I have sent everything. If a necessary order.
Petition was filed by your husband.
Yes.
Writ petition was dismissed.
Yes, your lordship.
Your contention is he is not paying me the maintenance.
Yes, your lordship.
Now he preferred appeal against this order.
Yes, your
Of
lordship.
dismissal of writ petition.
Yes, your lordship.
Now in writ petition, we will dismiss the appeal. You go and take steps before the executing court.
Grateful, your lordship. Grateful, grateful.
No one appears on behalf of the applicant. No accommodation has been sought for. Though the learned, what is your name?
Your lordship, Nikhil Kumar Gupta, your lordship.
So Mr. Gupta, learned advocate, appearing for the respondent number 6.
Yes, your lordship.
Present. Stopping you there.
তখন ছিল
Would appeal would against a master.
হ্যাঁ এই যে বললো যে টাকাটা পেমেন্ট করতে হবে the FIR may be FIR টা কি
Husband that no in order be made even if it is discovered
that any amount is due as on as on date on account of maintenance, and the FIR may be passed. দেখলাম কে করেছে
Do you have that FIR copy?
No, your lordship.
The 7th May 2016.
No, your lordship.
Who lost the FIR?
Husband.
Your lordship, husband.
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 ওরা আসবে না
The appeal is dismissed for default. They have dismissed it for default. Go and take a
Deeply obliged, you know, deeply obliged. And I appear on behalf of the appellant.
Lord, I appear on behalf of the commission led by Dr. Patro.
My lord, there are 3 candidates.
Just one second.
Yes, yes, I'm sorry, Miller. Probably, Miller, the matter has been assigned to my lords.
ম্যাজিস্ট্রেটের অর্ডারটা এক্সিকিউট করতে চাও পিটিশনার যদি না আসে তাহলে
ওকে একটা কাগজ দিয়ে দেবো
পাঠাও না এই যে আগের ম্যাটার হচ্ছে
সালে কালকে মেল
The order under appeal, your lordship will be pleased to find that from page 350 to 357.
Yes.
And I'm just indicating to my lords, my lords.
Order sheet. নামটা কি? অ্যাডভোকেটের নামটা কি?
চলে গেছে।
I'm just indicating to my lords. Milord, an advertisement was published on 29/12/20.
The pleadings are all complete.
Milord, pleadings are complete, Milord. There was a direction for filing of paper book, Milord. It's a change brief. Therefore, Milord, I say, Milord, at a stage when I came, Milord, I found, Milord, that the paper book has been prepared. Therefore, Milord, I say, Milord, I did not have the occasion to go through the particular the orders passed. But so far as,
You have not been given copies of the paper.
yes, I was given a copy of the paper book. I was given a copy of the,
Want.
I could not,
Ready to argue.
no. I have prepared because, Milord, I am only on the point that, Milord, what are the orders which have been passed in the matter. Milord, that I have the internet copies of the orders I have. But, Milord, whether, Milord, there was a direction for indicating that the paper book has been prepared, or this is there or not, this internal note, I am not aware. But, Milord, I have been handed a copy of the paper book. That's the thing, Milord. But however, Milord, this is a short matter. I can, the matters on record which is existing, I can make a submission.
But it was before Justice Talukdar.
Yes, Justice, before that, before my Lord Mr. Justice, the division bench presided over by my Lord Mr. Justice Subroto Talukdar. And before that, I appeared before the division bench of my Lord Mr. Justice Horish Tandon.
In this matter.
In this matter, I appeared before my Lord Mr. Justice Horish Tandon and before my Lord Mr. Justice Subroto Talukdar.
So both the benches have released the matter.
No. Milord, this I should indicate to my lords. Milord, the matter was heard by my Lord Mr. Justice Horish Tandon. They were hearing the matter, but Milord, at a stage when Milord, the division bench decided that with the pressure of the bench, Milord, they were not inclined to take up the matter. Then the matter went up to the Honorable Mr. Justice Subroto Talukdar. Now, Milord, the business of the court did not permit the matter to be taken up. Then, Milord, someone appeared before in the matter, prayed for Milord, yes. Now, Milord, your lordship may kindly consider that so far the present matter is concerned, this is in connection with the regional level selection test. Yes, Milord, prima facie, your lordship may, Milord, may be disinclined. But, Milord, if your lordship gives 10 minutes time, your lordship will be able to understand, Milord, what is the issue for which, Milord, these persons are, Milord, pursuing their remedies. Because, Milord, there were earlier round of litigations. In the earlier round of litigations, my lord will be pleased to find the order, Milord, which was passed by the Supreme Court. And, Milord, the Supreme Court on an earlier occasion, an order was passed on 17/12/2013. Authorities were directed to call the writ petitioners in counseling and recommending them from an appointment. Then, Milord, mandamus appeal was filed by the School Service Commission, and on 15th of March 2017, a judgment was delivered, Milord, thereby allowing appeal and quashing and/or setting aside the order of the learned single judge. Then, Milord, SLP was filed.
Where do we get this?
Milord, I am indicating. Page 65. Kindly see page 65 of the paper.
No, you tell us what is the matter about.
Yes. Now, Milord, the issue involved in the matter is that, Milord, there is a RTI information which we have obtained from the authorities. Now, the issue is that there is no mention of combined merit list in the rule. Now, the rules, Milord, which I duto copy rule. Now, Milord, kindly take into consideration those paper book. Milord, kindly take the rules of 2007.
No, we will come to the rules.
Milord, I am indicating because if your lordship
Story, what was the writ petition filed for?
Milord,
It was a writ petition filed for issuing necessary direction so that he may be appointed.
right, Milord, the prayers in the writ petition which kindly see the prayers of the writ petition.
There were 3 writ petitioners.
Yes.
Now the appeal has been filed by 1.
No, there are, Milord, there are 3 persons who are pursuing the remedies. 2 are the appellants. 1 was impleaded as a respondent because, Milord, 1 did not come. At a point, Milord, 1 did not come. Then he took out an application for, Milord, impleading him. And, Milord, subject to correction of this honorable court, Milord, it was allowed by the division bench of this court. And then, Milord, they are pursuing their remedies.
So you are also appearing for him.
Yes. They are all similarly circumstanced.
So there were 4 writ petitioners.
Initially, yes.
So, thereafter, appeal was filed by whom?
Appeal was filed. My lords, you will be pleased to find from the memorandum of appeal. My lord, just a second, my lord. I just because 358. This is at page 358, the memorandum of appeal. The appeal was filed by one Azizul Islam and Bijoy Kumar Ruidas. Has my lord got it?
So what happened to Mollik Kormokar and Arifur Rahman?
My lord, these Arifur Rahman.
They were impleaded as respondents.
Yes. That my lord will be pleased to find at page 360 of the.
So now you are representing only Azizul.
Azizul, Bijoy Kumar Ruidas and Arifur.
Arifur.
Arifur is respondent number 6 in the present.
All right. Your petition prayer was that give us appointment.
Yes. Now, my lord, your lordship may kindly consider.
Then you can place the order into the facts will come.
I'm grateful to my lords. Grateful.
Yes.
My lord, may I just interrupt, leave of my learned friend also. That is before going to the impugned judgment, if my learned friend places the Supreme Court decision in the previous writ application. From there, the
I think my learned friend will not interrupt. You know, I am placing the case. The may be allowed, the appeal may be allowed, the appeal may be dismissed. Why he is making this submission? Miller, then Miller, let him make the submission, then I will make the submission. Because I am not accustomed to this practice.
No, I am also not in the habit of interrupting my learned friends or very well. But the scope was limited as the Supreme Court has directed.
Yes.
Just a second. Page 350.
Then come to page 351.
Yes.
And start from the.
Yes. I'm grateful to my lords. The writ petition has a checkered history. A petition was made on in March before a learned single judge of this court on the allegation that though the writ petitioners and those similarly situated had passed the teachers eligibility test examination interview and were qualified candidates, persons belonging the petitioners in the selection list were called and given appointment. The writ petitioners a panel is however created in such a manner so that the number of panels persons impaneled are equal to the number of vacancies finally declared. On the face of it, the coordinate bench had fallen into error by treating the combined merit list as identical with the panel. The statutory rules will show that these two are not the same, and a panel is prepared by the regional commission on the basis of the. Yes, my lord, I'm sorry.
Page 351, the earlier writ petition was disposed of directing the.
Yes, as I told my lords, my lord, I submit before my lords. My lord, your lordship may kindly take into consideration on an earlier occasion, an order was passed directing the authorities to call the writ petitioners in counseling and recommending them for appointment, page 65. Page 65 of the writ petition.
Now,
Then, my lord, against that order, a mandamus appeal was filed. Mandamus appeal was filed by the School Service Commission.
It was 17 December 2013.
I'm grateful to my lords. Then this mandamus.
For the order or for pointing out the date of the order?
My lord, this.
You're grateful for what we were.
I'm grateful, my lord, for the patient hearing my lord is giving.
You are more patient.
No,
You're appealing both for the petitioners as well as the.
I cannot do anything. My lord, I cannot do anything.
They have searched you out, huh? That you appear for the petitioner as well as the respondent. That is why Dr. Patra is agreed that how a single council can. Yes. Yes. So 17th April 2013 was the order of the writ court.
Right.
Single bench. Now
Yes.
division bench passed an order, page
On division bench passed an order at page 126 to 131. This is an order which was passed on 15th of March 2017. This was in connection with the appeal filed by the School Service Commission.
Right. Now,
And my lord, the judgment was.
those that writ petition are also here. Now this was
Some, not all.
This was an appeal by SSC.
I say, my lord, some, not all.
Very good. This was an appeal by SSC.
Yes, that was the before the division bench. That was the
Dismissed. That division bench order.
the judgment was delivered, thereby allowing appeal and quashing and setting aside the order of the learned single judge.
That you don't have to call them for counseling and recommend.
Page 126 to 131.
Against that, you went up in SLP.
SLP was filed by the appellants, and on 4th of September 2017, the petitioners, Miller, kindly see for a second, Miller, page 68 to 69.
SLP order is at page
68, 69.
Appeal court order is at 126.
Miller, the appeal court's order, my lords will be pleased to find
126.
126 to 131. This judgment was delivered, thereby allowing appeal and quashing and setting aside the order of the learned single judge.
Right, but how does the SLP go back to page 68?
Now, Miller, this SLP was filed by the appellants against this order of 15th of March 2017. And on
68.
Page 68. No, not a page. The mandamus appeal order is on page 68 to 69. The order of the Supreme Court.
Yes. Place the order, Mr.
Miller, kindly see this order at 4th of September 2017.
Yes.
According to the petitioners, the advertisement dated 28/12/2011 contemplated filling up of 39,510 vacancies. Only about 22,000 have been filled up. Though a panel was prepared and candidates are available, the vacancies are not being filled up. It is submitted that though the High Court has held that nobody lower to the petitioners have been appointed, above contention has not been examined. The petitioners are at liberty to move the High Court so as to ascertain whether any decision has been taken not to fill up the vacancies from the existing panel. The special leave petition is accordingly disposed of.
Now you came back. Now you came back.
Yes.
So how did this order benefit you, Mr. Bhatt?
Yes. Milord, kindly see.
Now let us understand.
Yes,
Your
I am.
initial petition was that candidates having secured lesser marks
Yes.
have been given appointment.
Yes.
That was your main crux of the
I had twofold submission. First of all, Milord, in the rules, Milord, which I am handing over.
No. Rules
Yes.
we will go.
Yes.
Your case before the writ court was persons below me in rank had been given appointment. That
No,
is
I
why
had twofold
writ court
prayers.
said-
I had twofold prayers. First of all, in the writ petition, there is an indication that, Milord, about these rules. Now, I am only drawing my lord's kind attention to three independent provisions of the rules. Rule 2O, Rule 2F, Rule 2OI, and Rule 12. Nothing more in the matter.
For what? For what?
What purpose? Because you have to prepare a panel on the basis of the vacancies.
Now they have made an advertisement contemplating filling up 39,500.
That one, and I have also annexed the advertisement published on 29/12/2011, page 18 to page 23.
Very good. Now we are just one.
No, I'm just indicating to my lords, Milord.
The advertisement there were 39,000 and odd vacancies.
Yes.
A panel was prepared of how many candidates?
Now, Milord, this total panel which was published, Milord, I'm just indicating. একটা কথার একটা উত্তর 30,000. Milord, I have annexed the panel.
Panel was of 30,000. Now out of that 22,000 were appointed.
Yes.
And the remaining was
Not.
seats, like panel lost
Yes.
seats.
Yes.
So are you there in the panel?
My name appears in the panel.
Appears in the
I submit, Milord, that I have been called in the particular written test. I have been called.
No, your
Yes.
name was there in the panel.
Yes.
But they have given appointment only up to 22,000.
Now this
below that.
Yeah, no, Milord, yes, of course. Well, otherwise, I would have been given
So
appointment.
now the panel, according to them, has lapsed.
They
They cannot be given appointment.
Yes,
This is their
this is their stand. Milord, I submit to my lords, Milord, this submission of School Service Commission, the submissions, Milord, which they have made, I have just indicated, Milord, in my own way. First contention is that.
Now, what did the now on the basis of that Supreme Court order, you have moved the writ petition.
Yes.
Now, what did the writ court say? You are placing that order.
Yes.
Page 351.
Milord, I'm just indicating.
Your Lordships will kindly excuse me. Your Lordships, may I kindly be excused? My junior is here. Okay. Samla.
Yes, you can read, start from page 353. Therefore, at best, last para, up to Supreme Court of episode you have told us.
Yes.
Therefore, at best, the honorable.
Yes. Therefore, at best, the Honorable Supreme Court granted liberty to the petitioners to move the High Court, my lord, there are, I should submit, my lord, with my greatest of respect, that, my lord, while the division bench, my lord, passed this order, there were certain facts which was not taken into consideration by the learned single judge. This was,
This order.
yes, yes,
Now,
yes.
if you place the order, we
Yes, 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 yes. I'm sorry, my lord.
advise the Honorable Supreme
Honorable Supreme Court granted liberty to the petitioners to move the High Court by a fresh writ petition so as to ascertain whether the decision was taken naturally by the respondent commission not to fill up the vacancies from the existing panel. The Honorable Supreme Court expressly did not grant any remedies to the writ petitioners, varying or modifying the order of the division bench by which the learned single judge's order was quashed. As a necessary consequence of that, all that the writ petitioners could have done was to apply to this court for a mandamus, directing the respondents to disclose whether or not a decision has been taken not to fill up the vacancies from the existing panel. Instead, the writ petitioners have sought appointment from the panel, which they allege that they were part of, and this allegation is what was made also before the Honorable Supreme Court. The respondents have filed affidavit in opposition where inter alia at paragraph 11, they have carefully outlined the difference between the combined select list of merit where the petitioners' names have been enumerated and the panel from which the appointment was made. These two are not the same, and therefore, as indicated above, the petitioner was never impaneled. They are also, my lord, I will be showing that. Therefore, the question of decision to appoint someone from the panel lower than the writ petitioners does not arise. If the writ petitioners were aggrieved by the non-inclusion of their names in the panel, despite their names having been in the combined merit list or select list, they had option to challenge the final panel. Instead, they have confused the panel with the combined merit list and relied what they think was the panel. That apart, in the affidavit in oppositions, the respondents have categorically stated at paragraph 8 that since combined merit list is not a panel, it is a misconception that a candidate placed in the combined merit list should have been recommended for the post of an assistant teacher. Candidates are recommended from a panel and not from the combined merit list. This has been dealt with at paragraph 11 of the affidavit in reply, where a simple evasive denial has been resorted to. At paragraph 9 of the affidavit in reply, the petitioners have alleged that they were entitled to be impaneled, which in themselves show that they have not impaneled. Otherwise, the question of entitlement would not have arisen, but the position in the panel alone would have been mentioned. The language used is that it is stated that the said RLST was a recruitment process where only passing the examination did not entitle the candidates for getting calls in counseling and subsequently being recommended for appointment. Whether a candidate would be called in counseling dependent on whether he was impaneled, and the impanelment depended on the category, gender-wise, medium, number of vacancies reported, reservation, and other criteria as mentioned in the relevant recruitment rule. That is the West Bengal School Service Commission selection of persons for appointment to the post of teachers rules 2007 as amended in 2011. In such view of the matter, it is clear that even if I try to expand the compass of judicial review beyond what the Honorable Supreme Court has allowed the petitioners to agitate on merits and facts, the writ petitioners cannot on this writ petition succeed. So far as the failure of the commission to impanel the writ petitioners is concerned, if the writ petitioners had, instead of filing this misconceived writ petition, challenged the failure before the appointment process had been completed, some liberty would have been given to the petitioners. But as the facts now stand, nothing can be done, nor any relief can be given to the writ petitioners. I can only express my sympathy for the confusion under which both the writ petitioners and the legal advisors seem to have labored from the very beginning. Perhaps reading the rules would have helped these assistant teachers to know what they would have done. Besides, there is no pleading in the writ petition that the persons who are given appointment were lower than the writ petitioners even in the combined merit list, though such allegation has been made out only in the affidavit in reply, and such allegation inter alia was made for the first time in the reply. The writ petition therefore is dismissed.
Yes, Mr. What is it?
Now, my lord,
What is the wrong with this order, Mr. What?
yes. Now, my lord, your lordship may kindly consider that so far as the particular rules are concerned,
No, first, one thing,
yes,
can we go beyond the order of the Supreme Court? We can.
no, not at all,
So,
not at all.
Will you?
We
Mr.
have
Lord?
to, my lord, I submit to my lords, I submit to my lords that, my lord, there are two parts in the order of the Supreme Court. The, my lord, it seems, my lord, subject to correction of my lords, that at page 68, my lord, there was a specific indication that the petitioners are at liberty to move the High Court so as to ascertain whether any decision has been taken not to fill up the vacancies from the existing panel. This is number one. And number two is that, my lord, the court, my lord, had given this observation that it is submitted that though the High Court has held that nobody lower than petitioners have been appointed, above contention has not been examined.
It's submitted.
Yes,
It
yes,
is submitted.
yes, yes. I'm submitting. I'm saying by submitting that this is a submission which was made, court did not take into consideration. Of course, my lord, I stand corrected. Now, your lordship may kindly consider that
Page 65. In my view,
Oh, it is.
if it is found,
It has scored all the values.
that is state examination, subject and interview, in that event, they will record.
It appears. Combined merit ছিল তাহলে ও একটা জিনিস যে লোয়ার টু মানে any person lying in the combined merit list has got secure appointment.
Mr. Bhattacharya,
yes, my lord.
show us only one thing.
Yes.
Whether anybody in the combined merit list.
My lord, I'm showing it. That's what I want to show before my lords. My lord, your lordship may kindly take into consideration the combined merit list. But I am submitting to my lords that there is no provision of publishing of combined merit list, although in the information brochure, there was an indication that combined merit list can be taken, and that is beyond the statutory rules.
সঠিক observation কিনা সেইটা
এই এখানে ইয়েতে এই এখানে এই যে এখানে কত তোর এই যে হ্যাঁ 293 তোর নামটা কোথায় আছে? হ্যাঁ সেটা তো আমার দাগ দেওয়া আছে, কিন্তু তিনজনের তো তিনটে নাম, তো সেই পাতাগুলো বল। এইটাকে
show us
সবুজ
the
করে
combined merit.
yes I am showing to
There are two
myself
things.
I
One
yes
is combined merit list and
Yes.
the other is panel.
yes
Right?
yes
These are the two things.
my only submission, or rather Miller, not my only, I say Miller, I should not restrict this way, that Miller, I have Miller, what your lordship,
Mr. Bhattacharya,
yes
Justice, the first writ petition ordered of 17 December 2013,
yes
page 65.
yes
Therein the court said that in my view, if it is found that petitioners have crossed the hurdles of TET interview subject criteria, then only they can be asked to appear in counseling and may be recommended.
yes
This order has been nullified by the division bench. So first you tell us, before the division bench, this argument of yours that persons securing lesser marks have got the appointment, this was made before the appeal court.
Miller, I should not, I say Miller with the greatest of respect, because Miller, whatever submission I make Miller with a caution. I do not make any a statement or a reckless comment, because I say Miller that before division bench, I was not there. Therefore, I had entered
Division bench has annexed that charge, page 128,
128. Miller, just a second.
or rather page 129. Following and careful consider combined merit list.
Yes.
So the combined merit list has been extracted in the
Yes.
division bench.
No, this is not the combined merit list. I submit to my lords. I submit to my lords. Miller, I submit, Miller, your lordship may kindly come to page 293.
'93.
এই দুপাতের কাগজটা কোথায়? যেটা ওখান থেকে দেখাচ্ছে, যেটা ওই যে দুপাতের কাগজটা এটাই আমি তো এটা তো আজিজুলের, এটা পেজ 283 থেকে তুমি তোমারটা দেখাচ্ছ, তো ওটাও তো দেখানো উচিত।
68,
Detailed status information of candidates belonging to combined merit list. So you are saying that one is combined merit list, another is panel.
Right,
This is the
right,
distinction you
right,
are making.
right. And another thing which I want to say, for which Miller, I have also,
Now, what you are showing at page 293, Mr. Bhattacharya?
I am showing this, that this is a detailed status information of candidates belonging to combined merit list. Now, Miller, my contention before my lords is that, Miller, so far as the matter is concerned, that there is no provision of publication of the combined merit list. Why I say, my lords may kindly go into the rules. The rules say that whatever you do, you must proceed on the basis of the panel.
Where is the panel?
Panel.
293 is the combined.
Combined merit list.
Where is the panel?
Miller, I'm just Miller, on instructions I am submitting, but so far the panel is concerned, that is not with me, or that has not also been annexed in the paper book, because it is not with me.
No, but the division man said that it is here with us.
My lord, there is, I
Page,
cannot.
350, that
Three-
is page 126, you said.
120
That is comes at page, why the division bench has
made this comment.
extracted this combined merit list and other documents have been produced before us.
My lord, it seems similar that this is a
How that is
submission.
First man, merit position of the respondent such and such. এটা দেখেছো 120?
This is subject to correction, my lord. This is
What is this, Mr. Bhattacharya?
which, my lord?
Page 129 and 130.
My lord, I submit, my lord, that we find the following admitted fact on careful consideration of the combined merit list and other documents produced before us. Combined merit list. I find, my lord,
It's not with you. Then how your argument, if we can anticipate, is
yes,
that my name was there in
in the
the panel,
combined merit list. In the combined merit list as also in the
as well as in
panel.
the panel.
Of course.
Out of these 39,000 persons were appointed,
Yes,
but 22,000 vacancies were remaining.
yes, and my lord, the
First
fact.
tell us that what is your position in the panel?
No, not panel. I can show it from the combined merit list. That, yes, that, my lord, just, my lord, I show to myself, I show to my lord. You know, kindly come from page 293. My name appears.
কোনো ভুল নেই combined merit list এ, আবার ওখানে
অ্যাপয়েন্টমেন্টটা শুধু প্যানেল থেকে দিতে পারবে, কম্বাইন্ড মেরিট লিস্ট থেকে দিতে পারবে না।
My name appears at page 318 in serial number 1, 2, 3, 4, 5, 6, 7, 8, 9, 19.
কুমার রুই দাস, এই যে
19. Bijoy Kumar Ruidas.
হ্যাঁ বিজয় কুমার রুই দাস got it. Where is Ajijul?
And next, 283. Kindly come to page. No, that I should show from the beginning. This is Ajijul Islam. Page 283.
283.
283. It starts from Millard. Yes, no. I had showed to my lords.
93 you have showed.
Yes.
Another.
In that Bijoy Kumar Ruidas is here.
Yes.
Now in this combined merit list, where are the names of the other candidates?
These are the names.
No, your appellants.
Appellants. Yes, I am showing to, because what they have done, they have Millard.
Just 408.
Millard, the one your lordship will be pleased to find at page 283, serial number. This is a combined merit list going on.
Twice it has been annexed.
Twice, not twice, thrice. Kindly see, it starts from page 273. It starts from 273. My lords will be pleased to find it at page 283.
Page 283. Yes.
Has my lord got it, my lord?
283.
Yes. 283 Ajijul.
Where is Ajijul?
Here, my lord, from the bottom, 1, 2, 3, 4, 5, 6, 7. Yes.
So Ajijul merit rank position is
408.
And that of
854. Bijoy Kumar Ruidas.
And what about the other?
Millard, I have just 1 second, Millard. And the other is 340.
Next 305, page 305, why the name of Ajijul is not appearing? 408.
Millard, why I could not get it, Millard.
In page 305.
This is because, Millard, this is based on, kindly see, the particular category, the category of candidates. This is how, my lord, this is being done by the school. Yes, yes.
Candidate category, general SC, SC.
Yes.
There you showed us Bijoy
Bijoy Kumar Ruidas at page 318. Bijoy Kumar Miller, I am causing trouble to my lords. Kindly do excuse me.
854.
Haripur is 335 to 343.
Ajijul is what?
Ajijul is page. I had shown to my lords, my lord. Yes.
He is OBCA.
Yes, OBC.
And what about the other two appellants?
Milord, one is Bijoy Kumar Ruidas, one is Ajijul Islam, another is Arifur Rahman.
No, there are two more.
No, total two have come as appellant and one.
Are appearing for only the
Only two and one. That
one
is
is
three.
that. What is the name of that?
The name of that candidate, Milord, kindly to excuse me. This is Arifur Rahman. Arifur.
Where is that? Which page his name appears?
Milord, I am just, I have marked down, Milord, I just, এক সেকেন্ড আমাকে দেখতে দে Arifur. Arifur is, your lordships may kindly come to page 343.
কি writer?
কি উল্টো পাল্টা বলছিস 343 না পড়ে এসে এখানে এসে কোর্টে এসে গল্প করা আপনারা দেখে ওপর মেরে দাও
Yes.
340. I'm sorry, Milord, I stand wrong. 340.
Where does it appear?
Yeah, 340 in the middle.
Number.
Ajijul.
Milord, there is no numbering here. I am saying the number from the top. 1, 2, 3. Yes.
Arifur 228.
Yes.
28.
Yes. I'm grateful. Yes, I'm grateful to my lords.
And Ajijul was also OBCA.
Yes.
And only Bijoy was SC.
Yes.
So two are in the same. Your argument, Mr. Bhattacharya, is that my name was there in the panel, but the total panel was not filled up. So you please show us that from the 22,000 persons who were given appointment, you had obtained more marks than the 20 say last candidate who has been given appointment. Finished.
No, if you, I understand, Milord, what your lordship is indicating. Now, Milord, what I am indicating to my lords, or rather I am respectfully submitting before my lords, that
there is no provision of combined merit list.
There is no provision of combined merit list. Secondly, my lord,
there has to be a panel, and the panel must be at par with the number
vacancies. Yes.
So if we accept your contention,
yes,
you have to show us that a person below you in the panel have been given appointment.
Now, my lord, so far as
the alternative argument which can argue you at best is that when the Supreme Court has given this dictum that I can question the council, what have you done with the other vacancies? These are the 2 points.
I bow down to my lords. But
show us that this is the panel. My name is 22,001. I have secured more number than the last person who has been.
No, my lord, so far as marks is concerned, my lord, marks to তোমরা কিছু জানতে হবে সেটা ঠিক আছে so far as marks is concerned, I submit, my lord, I could not find any document in the panel, in the paper book. And also,
Mr. Bhattacharya, how can we help you?
Your lordship is indicating that how the court will cavilate.
Because Justice Banerjee has said that the scope of Supreme Court order is very limited. Scope is that you can question the SSC that why you have not filled up those vacancies. What is this? What happened? So his lordship went ahead and said that a contention has been raised that certain persons securing lesser marks have been given appointment. But that point has been brought on record for the first time in the affidavit in reply to the writ petition filed after disposal of SL. So I should
Yes.
not take cognizance of.
Yes.
You come across these two hurdles, we give you the order.
Now, my lord, I have not brought that judgment. I will produce that judgment that, my lord, even in any writ proceeding, in an affidavit in reply,
Mr. Bhattacharya, first you have to show us that there has been a discrimination.
yes.
Unless
Now,
you show
now,
us that,
now,
Mr. Bhattacharya,
yes,
how can we
no, very well. Now, my lord, your lordship may kindly consider.
Now you explain to us
Yes.
that in the division bench order which you are showing, that is page 126.
Yes.
What is this panel?
Page
What is the
126.
extracted?
You know, this I find, my lord, subject to correction of my lords, page 128 bottom, there is a clear indication.
The combined merit list.
Yes.
Yes. So combined merit list, his lordship has extracted.
Yes.
Of 20 candidates.
Of
Then
20
his lordship
candidates.
says that from the aforesaid table, it is crystal clear as to none of the writ petitioners stroke respondents was
Superseded by any of the candidates belonging to the same category.
So how this point can be reopened, Mr. Bhattacharya?
So kindly consider that this order which was passed by the division bench, this was carried in appeal before the Supreme Court.
Yes. Supreme
Now-
Court has not disturbed the order.
Now, my lord, the Supreme Court, the Honorable Supreme Court, my lord, subject to correction, my lord, kindly see the last line.
You have said that question I submitted.
Yes.
That my issue has not been examined. That was your submission. What
Yes.
is the order of the SLP? Order is that you can take appropriate steps. That is quoted in the appeal court order also.
We kindly see page 68, that is the order of the Supreme Court.
Supreme Court. Supreme Court order was that
Page 68. Page 68.
Page 68.
page 68.
Yes.
Let us read the order together. Petitioners are at liberty to move the High Court so as to ascertain.
Ascertain.
What
Whether-
ascertain what?
Whether any decision has been taken not to fill up the existing
vacancies from the existing
vacancies
panel.
from the existing panel.
So you show us that these 22,000 candidates were appointed. Out of 39,510 vacancies, only 22,000 vacancies were filled up. First paragraph of SLP order. According to the petitioners, the advertisement
Millard,
contemplated page 68.
Yes.
39,510 vacancies, only 22,000 has been filled up.
Yes.
Though a panel was prepared and candidates are available, vacancies are not being filled up.
Yes.
Suppose they lose on that issue.
Now, Millard, it is,
Then it
I
is a
understand.
question that whichever candidate below 22,000 up to 39,159 must be given appointment. Show us that you come within that zone. Finish.
Millard, I have prepared a chart. I have prepared a chart from Millard. I say, Millard, I appeal to my lord,
Justice,
Millard.
in the
Kindly,
division-
Millard, I
Mr.
may
Bhattacharya
take
ji,
my lord's time.
Curtail it down to, please satisfy us, Mr. Bhattacharya ji,
Yes.
that 20 list of candidates in the division bench order at page 126.
Page 126.
Chart is at page 120.
126, yes.
This is combined merit list, extracted chart of 20 candidates.
Yes.
Why it has been given? Why 20 candidates was taken up?
No, Millard, I think, Millard, my lord's, Millard, no.
Tomorrow?
Tomorrow or day after tomorrow, I leave it to my lord.
Tomorrow.
ঠিক আছে?
Tomorrow.
ঠিক আছে। করো, আমার কোনো অসুবিধা নেই।
Before rises.
কালকে কালকে অ্যাসাইনমেন্টের